Senator Dionarine.
Thank you, Mr. Vice President, for the opportunity to contribute to the debate rather late in the stage. When we start to think about the real estate industry, we've heard time and time again during the course of the debate that it accounts for around 2% of GDP, and which is in dollar value is around $3 billion. But since 2012 to the period of the first quarter of 2019, the real estate sector has not really grown. It continued to account for around 2% of GDP. When we start to look at real estate credit in the private sector, it accounts for around $24.2 billion as of January 2020. And these figures are according to, first, the Central Bank of Trinidad and Tobago, and the GDP figures is according to the Central Statistical Office. And that is real GDP that I'm referring to. But the real estate industry, Mr. Vice President, is considered an industry that is relatively high risk when it comes to money laundering and terrorist financing. According to the FATF Recommendation 28, real estate businesses must be submitted to strict regulatory and supervisory regime. This legislation, in my view, introduces some structure and inflicts some control in the industry by regulating the profession. Right now, we have a situation where the required education, standard of practices, code of ethics are limited to 2 associations: the Area Association, the Association of Real Estate Agents, and also the Trinidad and Tobago Real Estate Association, the TTREA. According to the FIU 2019 report, 25% of non-compliant firms are those who come from the real estate agents, from the real estate industry. Between 2017 to 2019, suspicious activity reports and STRs moved from 4 reports to 13 reports. So what we have is a situation where many persons are operating in the real estate industry. They don't abide by the required standard of principles, the code of ethics, and the required education, and may not necessarily possess the required education. So as I said, the bill attempts to introduce a regulatory mechanism which would facilitate supervision by encouraging transparency and accountability. How is it doing this? It is doing this by allowing the registration of sales associate, brokers, land developers. It's establishing a licensing committee and association, a disciplinary committee. It's facilitating the maintenance of records for around 6 years for sales associates and real estate, sales associates and brokers. It's ensuring education in the field prior practicing, and it's encouraging FIU supervision and oversight. That is just to name a few, Mr. Vice President. Now, Mr. Vice President, I would like to give some brief comments on specific clauses of the bill, and it is related to the public access to the registry, the renewal of the registration. I have one concern with the disapplication clause and the handling of money by the sales associate. And also I have some additional comments on the keeping and maintenance of proper records. So, the public access to the registry. Mr. Vice President, I would have to agree with Senator Sobers, because I too believe that this registry should not be subjected to a prescribed fee. It should be free information to the public. I do not see the need for a cost to be attached to it. Data is something that is shielded in Trinidad and Tobago so much, and it should not be the case. Registers should be accessible, free to the public, and in an online platform, on an online platform. So the public could see not only the registered sales associates, brokers, and land developers, but they have the ability to look at all the real estate projects for which these sales associates, land developers, and brokers are engaged in. This makes realty transactions hugely transparent. This was actually adopted in India upon the implementation of their Real Estate Regulation and Development Act in 2016. It resulted in significant improvements in the transparency of the industry. I move on to the renewal of the registration. And with respect to the renewal of the registration, I too have to agree with Senator Sipasad. Renewal for every 3 years can prove to be burdensome. You're subjecting practitioners to maybe unnecessary risk should any delays and malfunctions happen at the Registrar General Department. Renewal request, according to the legislation, says that it must be filed at least a month prior to the expiration of your registration. The Registrar General has up to 30 days to make a determination. That is just to assess the renewal request. That is not actually granting the registration. Risks of unregistered sales associate handling affairs of ongoing transactions need to be considered. Delayed registration would mean that they would have a period of time where they are actually practicing illegally. Maybe consideration can be given to lifetime registration, but I hear the Attorney General's argument with respect to that. He's really trying to prevent defunct companies, defunct businesses, real estate businesses, breeding on the Registrar General records. But I would also suggest granting sales associates with a license and have that license be renewed for every 3 years. With respect to the disapplication clause, Mr. Vice President, the disapplication clause reads as follows, and I quote, "A person employed by the state, a state-controlled enterprise, or a public body who conducts real estate business in the course of their employment." The law does not apply to those persons. I am not comfortable with this. I hear the Attorney General's argument, but if the Public Procurement Act was fully proclaimed and operational, I would have felt a little more comfortable. In the Public Procurement Act, for the sale and purchase of state lands, it is adequately covered there. But when would it be operationalized? We have been continuously dragging the implementation and the full proclamation of this act. The ongoing situation with the COVID-19 crisis means that there is going to be another drag on the procurement legislation. So my question is, right now, what parallel system would be put in place to address the sale or the open transactions that take place with state lands? Open transactions of state lands take place right now through the Commissioner of State Lands. And from what I understand, the Commissioner of State Lands performs with minimal resources, and it makes public land management quite inefficient and a great cause for concern. I move on to the handling of money by sales associates. Clause 75 indicates that the sales associates cannot handle the client's money without a license, which is understood to some extent because the broker is the one who holds a client account and holds the monies received from sales. However, sales associates tend to facilitate transactions quite frequently. And to me, that is considered handling money. Collecting payment from let's say, a tenant carrying it to the landlord, to me is considered handling money. So without attributing a proper definition for what handling money is, it is a little bit unclear, and I think we need to be a little more explicit when we talk about handling money. The maintenance of proper records. Mr. Vice President, looking at clause 45 and 46, it is very commendable that we are moving towards encouraging the maintenance of records for a period of around 6 years. And I looked at the types of records in the law that are being required. However, some of the documents to be maintained by the sales associate seem to be duplicative, and some of it is quite confidential. Confidential documents for which brokers and brokerage firms are liable for, and liable for by the FIU as they are mandated to secure certain documents in a certain way. So, is it that we are going to expect the sales associate to adopt similar protective measures when it comes to the securing of confidential information? The experience of members that constitute the board, this was also already mentioned during the debate, but I would like to say one thing on this. The learning curve, from what I understand during my conversations with experts in the field, the learning curve for the real estate profession seems to be a very steep learning curve. During the first 2 to 3 years, they begin to, where they become qualified, they begin to grasp how the business really works. And 2 years after that, they become fully equipped to handle the field, to become familiar with the different types of real estate transactions. And I honestly believe serving members of the board should have a broad range of experience over over various cross-sections of type of real estate transactions, and I'm not sure if that would be included by a person who has 5 years experience. Maybe we should consider extending the requirement to around maybe 5 to 7 years, or maybe 7 to 10 years. With respect to the transition from the existing association to the new association. Now, I understand there's the Association of Real Estate Agents, and then there's also TTREA. The Association of Real Estate Agents, from what I understand, was formed under a private act of Parliament. Now, it is acceptable to have a transition period of 12 months to 18 months under the Act because it is subjected to extension. And it gives time for the real estate practitioners to put things in place so that they can obtain the necessary qualifications. Some certification programs, from looking at the Reutech website, to become certified as a sales associate, you need to complete a 12-week program. To become a real estate broker, there's a 2-year program. And we have to adapt. We may have to consider adapting these programs to facilitate the transition or incorporate some combination of experience and education. I would not say practicing only as a requirement. History of practicing in the field would automatically exempt persons because they could be practicing in the field for a very long while and been practicing incorrectly or fraudulently. We may also have to extend the transition period. Now, the issue with the commencement of the first board, this issue was well ventilated. I think that maybe consideration should be given to both practitioners at the Association of Real Estate Agents and also the TTRA when forming the first committee. And I think that is the intention of the Attorney General. What is missing from this bill, though, Mr. Vice President? To me, it doesn't provide sufficient regulation required for land developers. They are not required to maintain records. They are not subjected to any audits. They don't have any license. Thank you. They don't have any license. And they are handling clients' money, and to a larger extent than real estate brokers in some instances. So, and also, land developers tend to place a high and increasing risk or threat to the environment. I expected to see a high priority being placed on urban planning and environmental sustainability in this bill. But I suspect that with full implementation of the Planning and Facilitation of Developments Act 2014, it would probably be enforced in that legislation. So, what are we going to see for the future of tracking transparency in the real estate industry? The property business registration system to automate land registry in Trinidad and Tobago. This is a project that has been ongoing with the Inter-American Development Bank going into 7 years. January 2021 would be 7 years since this project has been operating. And the purpose of the PBRS system, which actually costs US $35 million, is to really link land title registries and the departments of births and deaths. So that would allow us to track fraudulent behavior in the industry. We also need to strengthen the police service division, add additional fraud investigators, and document examiners. Mr. Vice President, last thing I would like to say is that in order to adequately or sufficiently tackle this issue of transparency in the real estate industry, we also need to take into consideration the full implementation of the Land Titles Package, the Registration of Titles Act, the Land Adjudication Act, and the Land Tribunal Act. So, Mr. Vice President, with those few words, I would thank you.
Senator Amin.
Thank you very much, Mr. Vice President. And I want to especially thank the parliamentary staff who ensure that the area we speak in is sanitized every time a speaker comes to this podium. Mr. Vice President, I intend to be very brief in my contribution to this Real Estate Agents Bill 2020. Mr. Vice President, the opposition agrees that the real estate industry needs to be regulated. For quite some time, there are those who have called on the authorities to do so, and the fact that it is happening is a positive sign. The real estate industry, and not necessarily real estate agents, is a space where a number of illegal activities can take place, or rather, the proceeds of illegal activities can be covered up, money laundering, and so on. Mr. Vice President, that I don't feel is adequately covered in this bill, but of course there's space, and I know that members of the government did indicate that there are other pieces of legislation we could expect. So, Mr. Vice President, we await those pieces of legislation coming. I wanted to raise a few matters that I hope could be addressed either on the floor or in the committee stage. Within this bill, in dealing with the establishment and composition of the Real Estate Licensing Committee, there's a clause that provides the grounds upon which a person would be disqualified from being appointed as a member of the committee. So it includes A, is an undischarged bankrupt, B, is of unsound mind, C, is convicted for an offense which carries a term of imprisonment of at least 12 months. So the person doesn't have to be convicted or sentenced to 12 months in prison, but the offense must carry at least 12 months imprisonment as part of it. The magistrate, of course, may have had discretion. This offense does not have to be an offense under the Financial Regulations Act. It does not have to be an offense concerning the Integrity Commission or any other or fraud or any other type of activities concerning money. It is any offense. Madam President, Mr. Vice President, I just want to draw to the attention of the Senate that having regard to the fact that any crime, regardless of the nature, can fall under this measure. A person in their 50s who committed a crime in their youth could never possibly in their life practice as a real estate agent. We talk so much about rehabilitation and getting people back into society. I am sure Brother Wayne Chance, if he were alive today, would have something to say about this. There are people who would have served sentences, who would have been completely rehabilitated, reintegrated into society, and leading a clean life, who would, by this clause, be totally exempted, or, well, not exempted, but disqualified from ever receiving, from ever being a part of this committee. So, Mr. Vice President, I want to suggest that we have a time frame within which a person can be allowed after this offense is committed, or some other measure that would allow a person who would have served their time, completely reformed, back in society, especially where it is a mature person and decades may pass, and this was a crime committed in the ignorance of youth. So that is for the consideration of the committee. Mr. Vice President, I also want to, I think one of my colleagues before raised it, so I'll just endorse the removal of a member, the grounds on which a member can be removed from the committee. That requirement for misbehavior in office or bringing the office into disrepute. So the other measures are if the member is declared bankrupt, is of unsound mind, is unable to perform his duties, is convicted of an offense, misbehaves in office, or brings his office into disrepute. And the other one is for any other reasonable cause. Those two I have a problem with. At whose discretion is this person going to bring his office into disrepute? We have people in the highest offices in this country who are accused of things, and when the truth comes out, you realize it is an absolute fabrication. If a person is accused in the public domain, if via social media, if via traditional media or some kind of propaganda to attack a person's character, an accusation is made, will that be considered? And who determines if a person brings his office into disrepute? So I think we have to be a little more specific. If a person commits a crime or is alleged to commit a crime or commits some kind of misappropriation or fraud, anything within his industry and within the transactions as a real estate agent or any other type of business, and the person, it is in fact a crime, then the person will be charged. We have to put something a little more concrete there. I don't think it is for someone to simply say, well, you brought the office into disrepute because of something that is not measurable. So those two I have a problem with. Brings the office into disrepute. We have to be a little more specific. Quite frankly, if a person commits a wrong and they are charged, it will fall under the previous measure, which is convicted of an offense which carries a term of imprisonment of at least 12 months. Or you can say if a person is convicted of an offense that involves financial irregularity or financial, some kind of criminal conduct where money is concerned, or under the Integrity in Public Life Act, or a fraud, under the fraud, the laws concerning fraud in Trinidad and Tobago. So I feel we could use that instead of saying, just vaguely saying, brings his office into disrepute. And of course, my colleague, Senator Sobers, spoke of the point of a person being disqualified for any other reasonable cause. Who determines what is reasonable? That is too vague, and I do agree with my colleague in that regard. Mr. Vice President, there's also another small point. Persons who are concerning the procedure for persons desirous of objecting to an applicant's registration, so that in this bill, the Registrar General, upon receipt of an application, must publish the notice of the application in the Gazette. I don't know who reads that anymore. And at least 2 daily newspapers in Trinidad and Tobago. The number of people who actually read newspaper is dwindling, Mr. Chairman, Mr. President, Vice President. But it asks that the application be published in the Gazette and in at least 2 daily newspapers in Trinidad and Tobago, specifying a date by which a person may object to the registration of an applicant. Mr. Vice President, given that we are in a digital age, never mind that we have had a little spoke in the wheel because these children are not getting laptops in schools anymore, but the fact is that fewer and fewer people are going to read the newspaper. Nobody's going to buy the newspaper to look out to see these type of things. If a person wants to find something in the classifieds, they may buy a newspaper for that. But generally, people go online. And for this purpose, I think, Mr. Vice President, I think we have reached the stage where we could it should be published on our website. So that could be added to Gazette and the daily newspapers. The ministry has a website. The Registrar General is part of a ministry, and I'm sure they would have their own page. And based on the present administrative structure, we should place something here about publishing it on our website as well. I think that is mandatory. Mr. Vice President, the other point I want to make is that many of the speakers before spoke about the Association of Real Estate Agents of Trinidad. And as well, they are an umbrella body. There's an act of Parliament that gives them life. But there's another agency called the Trinidad and Tobago Real Estate Association, which is a different body. And they have been operating for many years. They are of the view that the Association of Real Estate Agents do not represent the interests of all the agents, that they only represent a small group. They are very active as well. No mention was made of them, but based on the existing legislation, based on the fact that area is enacted on an act of parliament, they may have to get in line. So whoever is on the government bench might be able to share with us if they did have any conversations with them. Now, one of the things that they are recommending is when it comes to the registration of real estate agents, there is a deadline so that the persons who have been practicing for some time have a stipulated amount of time in this act by which to register. Persons who have not practiced before cannot begin to practice and then register. They must register first. What the TTREA is suggesting is that existing agents be given a longer period of time in which to register. They are also asking that where Clause 9 deals with the qualification for registration as a real estate agent and indicates that an individual must satisfy the Registrar General that he is at least 18 years of age and is in possession of the prescribed qualifications. We in Trinidad and Tobago have people who have practiced and know the thing better than people who study and are certified. And I think we have to give consideration for agents who have been practicing for a number of years, who may not have what is considered the prescribed qualifications. Are we then eliminating those persons with this new system and this new requirement? So at one time we had a program in Trinidad and Tobago where people who were involved in skills, who were masons and plumbers and so on, were allowed to participate in a program that would give them a certification that put them on par with somebody who studied and went to get their certification. So it means that the practical knowledge is taken into consideration, that those people who have been practicing as real estate agents for many years will be allowed to be considered even if they don't have the prescribed qualifications. One suggestion is people practicing over 5 years. Of course, a person could be practicing for 5 years, but practicing irregularly. So we must come up with something that is relevant to the industry and that will be reflective of those older persons. Mr. Vice President, I also wanted therefore ask about, thank you, about persons who practice, who are real estate agents part-time. I think somebody before me mentioned that there are people who are housewives, well, it's called a stay-at-home moms now, but they do this thing on the side. This is not their full-time occupation. They may sell a property once every few months. It's not something they focus on. They will be required to pay the same membership fee. They'll be required to go and renew their license every 3 years. 3 years might pass and they have not sold a property. How do we treat with that? Should we have a separate category? There are also people who might want to one-off. I may have a friend with a property, and I might know someone who is looking for a property, and between them they decide to pay me a commission. How do we treat with that? That person is not required to be registered as a real estate agent. Is it that a person will now be not permitted to facilitate such a transaction? Because you would have to explain your funds to the bank. So I think we have to make a provision for part-time real estate agents, people who transact below a certain sum per year, or conduct a certain number, less than a certain number of transactions per year. I think we have to make that distinction, because there are people who are in this professionally, and there are people who do it as a one-off. And of course, when things are very slow, how do we gauge? I mean, a long time might pass before an agent sells a property, actually sells a property. So I think we have to consider that. The other thing I wanted to mention is foreign buyers, people of other nationalities who purchase lands in Trinidad and Tobago, and agents who facilitate them. I thought it would be useful for us to have a clause here where we should notify in some special way, where the real estate agents are required to notify when a foreign national is purchasing lands. And I say this because we could have, when you add it up, quite a bit of lands in Trinidad and Tobago being owned by foreign nationals. It happens in Tobago. I know at one time people was talking about how do we put a stop to that. Maybe we have to have a little something extra for real estate agents to declare or to indicate where the person who is purchasing the property is a foreign national. Two more points. One has to do with the clause that allows a broker to surrender his license to the committee. So where the committee receives a surrendered license, the committee can cancel the license. It has to give notice of the cancellation to the Registrar General and the supervisory authority. Of course, where the person dies, it immediately is cancelled. But this gives the impression that a broker could just throw in the towel at any time. He could surrender his license at any time. But there are provisions which outlines a broker, the duties that a broker, or the obligations a broker has to a client. So you can't halfway through throw in your towel. I think we have to make an amendment to give consideration and effect to the duties that are outlined in, so that it is not just immediate. And there's an overriding duty that is owed to the client under the Act. So if we could have a better look at that, it would be good. The other thing, Mr. Vice President, the composition of the licensing committee. I will not read out what the qualifications of all the members are, but there are provisions for 3 attorneys at law. Apart from 5 years experience, 7 years experience, and so on, the number of years, 10, 7, and 5. There are no other requirements. So a person who is a criminal lawyer could be appointed. A person who is practicing in land law could be appointed. I think we have to be specific. There are areas of law that are very specific that people are qualified in. And whether the person is, we have to say whether they are practicing in that area, such as real estate, a background in conveyancing, and so on. Are we going to put a copyright attorney here, a criminal attorney? You know, so we have to, I think we have to put in something in there with regards to their area of expertise for these attorneys at law. Mr. Vice President, with these few words, I want to thank you for this opportunity to contribute.
Senator Leiter. That's one not just in mind. Yeah. All right.
Thank you, Mr. Vice President. And again, I'd like to say it is indeed an honor to participate in this bill, a bill which the opposition sees as a very important bill. The opposition sees this bill important to stakeholders of the industry. They see it important to the government, and we see it important to every citizen of Trinidad and Tobago. Mr. Vice President, we support this bill, but we support a bill that has fairness and transparency attached to it. But, Mr. Vice President, for me personally, this is an important bill. Being the son of a retired real estate agent of over 25 years, Mr. Vice President, I would have heard a number of horror stories over that time. If you permit me, Mr. Vice President, I will cite a few stories. There have been situations, Mr. Vice President, because of no legislation. You have stories of two real estate agents working together to sell a property, but one being unscrupulous. And when the deal is closed, the commission is not split. And there's no redress. Either the person who is selling or unlisted it has not given the commission to the agent who has partnered and sold it, or the person who has partnered to sell it has gone around the back and circumvented the listing agent and cut a deal at the side. There's no recourse. There have been stories, Mr. Vice President, of persons creating fake identification, as we heard the Attorney General speak about it earlier, that would match a deed, selling it at a fire sale, cash, unrecorded cash. And then what happens? 3 years later, the developer is coming to build on the land, and in comes the rightful owners with the real identification. And in fact, only 2 years ago, Mr. Vice President, this story is the one that shocked me. A colleague of mine who owns a quarry, there was fraud happening down at the land register. In comes an unknown party with a deed in their name, storms the quarry with armed personnel and takes over the quarry, puts out the rightful owner. It took my colleague a couple of months to rectify it with police, with the courts. It was a nightmare, Mr. Vice President. But my parent, having complained, and many other real estate agencies, or agents, beg your pardon, complaining about this, many of them had no real guide other than this association we call AREA. AREA, this unofficial association, was the one set to create rules and policies. And Mr. Vice President, this is an association that has existed for more than 30 years. They have 30 years experience in this business. They have 30 years experience in creating policy, and they have 30 years experience in these horror stories that I talk about today. And Mr. Vice President, this is why I have come now to reiterate the point that my colleague, Senator Mark, has made about the importance of AREA in this bill, and the concern from the opposition that we are not seeing where AREA is placed. We are seeing a battery of lawyers, not persons experienced in the real estate business. And I want to draw reference again to what my colleague said about Bahamas. They understood the bureaucracy of these land register offices, the overwhelming burden that these government agencies have. We're no different in Trinidad and Tobago. There is bureaucracy. We are overwhelmed. You speak to anyone who's tried to purchase real estate or sell real estate in this country, and they will tell you the bureaucracy. They will tell you how long it takes to get anything done. And here we are coming to put a burden again on a government agency. When Bahamas, seeing this, created what would be their version of area, they empowered that agency and gave them the legislative powers to run this part of the industry, to make the policies and to regulate the policies in this industry. Now, the Honorable Attorney General was very right when he said that land is one of the most valuable assets that we have in Trinidad and Tobago. He's absolutely correct about that. But I ask you, Mr. Vice President, is land any less of a value for Bahamas? In fact, I want to say to you that land might be one of the very few things that Bahamas has in value. Their land, their beaches. They don't have offshore oil and gas. Correct me if I'm wrong, they don't have a large manufacturing sector. Their business is tourism, land. That's what they have. I don't think they have much agriculture. So why would Bahamas get this wrong? And that is why we are asking the Honorable Attorney General to consider the wealth of knowledge that an association like AREA has in shaping policies, procedures, and in taking away that burden from the Land Registrar's office. You see, Mr. Vice President, this leads me on to my very next point. You see, Mr. Vice President, I almost feel as though I have what they used to call it, déjà vu, because it was only yesterday we were talking about the wide powers of one single person or one single entity. I want to draw your reference, Mr. Vice President, to 12.3. And in 12.3, this, Mr. Vice President, is where the Registrar General is providing license for real estate agents. And again, Mr. Vice President, we see all these powers coming to this one person, he or she. Again, I will repeat what I said yesterday. This is almost draconian in nature. What happens when a young, aspiring real estate agent, someone who wants to get into the industry, what happens when they register and they apply? And what happens if they have a personal grievance with the Registrar General? What happens if there is some sort of political interference with that individual? What happens, I think another colleague said, the gentleman or the lady wakes up on the wrong side of the bed and decides you don't qualify. What is your form of redress? Well, if you permit me to read, Mr. Vice President, in section 12.3, an applicant who is aggrieved by decision of the Registrar General under subsection 2 may appeal to a judge of the High Court. Mr. Vice President, that is why I said I had déjà vu. It was the same onerous process. I asked the question to the Honorable Attorney General, why such a leap? Why such a costly venture? What young potential real estate agent has the financial capacity to take this to the High Court? which one of them has the time to take this to the High Court before they decide, you know what, I don't want to be a part of this industry anymore? So we are restricting people. So my question is, should there not be an internal independent appeal process or a tribunal set up as a go-between, in between the decision of the Registrar General and the High Court? I mean, Mr. Vice President, I'm sure you could agree with me, the High Court is also overburdened. There is a backlog. How long will it take to get redress? Should there not be this independent tribunal that one can go to for redress? That is what I ask. It is the same thing as yesterday. So I humbly suggest to the Honorable Attorney General that when we get to the committee stages, he considers this part in particular, because we can be restrictive to people. This, Mr. Vice President, is draconian. Mr. Vice President, another of my colleagues touched on this point, but I too would like to touch on it. I take you to section 16(2). And if I may read, the Registrar General shall, upon payment of the prescribed fee, allow any person to inspect the public register during the normal business hours. Now, Mr. Vice President, in the age of technology, when speed is the order of the day, are you saying to me that if I want to find out if a real estate agent is properly registered before I buy a piece of land or sell a piece of land, I must go down to this office, pay a fee? And I wonder if I should say fee or should I say a tax? Because we're getting accustomed now to everything being taxed. Is a tax for this? Is a tax for that? Is this a tax? Well, why don't we just state that it's a tax and done? But, Mr. Vice President, I said that we are at the age of technology. We should be able to go online, be able to access this list electronically, and make quick decisions. What if there's a hot piece of land that I want to buy? What if? But I have to go down by the register office and pay a fee and find out. Well, the length of time it takes me to do that, somebody else come and huff the land, and they're gone. So that puts me at a disadvantage for wanting to do the right thing. In fact, I think, if I am not, I could be corrected here, but I think in the Law Association, one can go to the Law Association to find out if a lawyer is properly registered, etc. Cuts past the bureaucracy. Why are we going back? We have an opportunity to go forward. Why are we going back? Now, this process may be easy for somebody like myself living in Port of Spain, but what about the small man in Cedros, in Toco, in Mearo? What about that person? He has to traverse all the way to town to find out if this real estate agent is properly registered. It is inefficient, it is obsolete, and I would like to make a recommendation to the Honorable Attorney General that he considers putting this as a matter that is accessible online electronically. You see, it all ties right back into the same thing, you know. It all ties back into sending this to the registrar's office, the land registrar's office. And should we have done exactly what was done in Bahamas, an empowered area to be the checks and balances, the policy makers, the person you go to for redress, the person you go to for information, to make information a lot easier and accessible. If we did that, then we would be a more progressive society. Mr. Vice President, I will not worry to go into too many of the other areas because my colleagues have done what I would say just desserts in addressing many of the issues that we have here today. The only other question I have, and I seek a bit of clarification, is on, thank you, Mr. Vice President. The Honorable Attorney General did mention, rightfully so, in Section 5, that that section did not include bailiffs or auctioneers who sell or auction pursuant to a court order. I would just, once we get to committee stages, I hope for a little bit of clarification on that, why they weren't included there. I'm sure he has a reason behind that. Maybe it's something I missed, but I'm just raising it so that in committee stage we can get some clarification on that. So, Mr. Vice President, as I close, I say to you, it is a good bill. It is a long-awaited bill, but it is a bill that needs more fairness and transparency attached to it. When I listened to my colleagues earlier on many of the other points, some of that I did not consider myself, I opened my eyes, and I opened my eyes wide. And I asked the question, are we a progressive nation, or do we want to do the same old, same old? We asked the Honorable Attorney General to consider these points. We look forward to it. And Mr. Vice President, I look forward to seeing this bill passed. I look forward to supporting it, but I look forward to the fairness and the transparency being injected into this bill. And with those few words, I thank you, Mr. Vice President.
Acting Leader of Government Business.
Thank you very much, Madam Mr. Vice President. Thank you for the opportunity to speak on this bill, the Real Estate Agents Bill. A tremendous amount of work has gone into drafting this bill, Mr. Vice President, and the AG will attest to that. And two of my colleagues, Senator Mark and Senator Leiter, have attached themselves to the Bahamas model. And I want to respond to that simply by saying, if you go to the U.S. Embassy site for Bahamas, you would see a section labeled Real Estate. And there is only one thing in that section. It's a caution, and it reads like this. A number of U.S. citizens who have purchased or sold real estate in the Bahamas have reported tremendous difficulties in the process, some even losing their entire life savings. For example, U.S. citizens have reported that after purchasing property in the Bahamas, they discovered that the seller did not have clear title or indisputable ownership of the property. Some of the incidents reported include high-end real estate development projects on family islands, where the development project was not completed and individuals could not get their money returned. I'll stop right there. I don't want to inflict any further damage on the real estate industry in the Bahamas. But Mr. Vice President, the Bahamas made several attempts to bring their real estate industry together under some sense of organization. And prior to 1995, when the legislation dealing with buyers and sellers and brokers was enacted, there were several failed attempts in the Bahamas. And even after 25 years of having the legislation we are now trying to put in place, the U.S. Embassy warns that people have lost their money in Bahamas. And if you Google the words real estate fraud in Bahamas, there are a lot of things to read concerning agents and attorneys. So it is not that the Bahamas and the complete regulation of this industry by the agents would be a magic wand for the control. It is what deals with the issues that we have to deal with in Trinidad and Tobago. And without giving it much thought, I made a quick list of 10 words that are typical in land transactions in this country. Top of the list, fraud, incomplete transactions, conversion of money, which is an offense, misapplication of money. Some of my colleagues have gotten into trouble for that. Exorbitant fees and charges, poor conveyancing, misrepresentation, mistakes, lack of approvals, and lack of capacity to conduct transactions. That list could easily be 500 given another 10 minutes. You see, this bill would not work on its own. I remember in 1981, I was still in primary school, but I was following the Parliament. And I remember the Attorney General, Russell Martino, now Senior Counsel, putting in place a series of bills relating to land and regulating land in the country. He also put in place legislation to deal with succession planning and wills and estates and so on. And those have remained on the books since then. And what we've tried to do, we've tried to deal with land by 4 pieces of legislation. I call them the suite of land law. And I remember the Senate, it must be history created. Remember the Senate sitting in one session and dealing with 3 of those bills in one sitting. And that was the suite of 4, where we dealt with the issue of limitations of action in relation to land matters, the issue of squatting and the time frame in which you can acquire or extinguish the title of the state in relation to state land, and some other matters including the amendments to the Land Tribunal Act and other matters relating to law. We have the registration of deeds legislation to be dealt with. We dealt with the facilitation of development amendment. We still have on our order paper the urban planning profession to deal with. We dealt with valuation of land, and we dealt with property tax. All of those things work together. And these things work to attack one thing in the main, and that is this issue of fraud in relation to land matters, fraud. And on any given day in this role I have, I could tell you about fraud. And even if I didn't have this role in my practice as a solicitor, I could tell you about fraud. But Mr. Vice President, the Honorable Attorney General, when he speaks in the winding up, I am sure he will talk about Clause 6. And you should name that clause after me, Honorable AG, the developer clause. Because, Mr. Vice President, it's one thing that has troubled me as a solicitor in this country and as a citizen of this country. And I raised it at a joint select committee once when we had Town and Country and EMA and those agencies before us. Mr. Vice President, if you if you go on Facebook and you search the words land for sale, you'd get things like this, and I read it into the record. Lots for sale, 50, 60, 70, and 100,000. Roadside Tabaquite, a phone number, and it says no TC, no Town and Country approval. That is the most aggravating thing. I could see on any advertisement in this country. No town and country. Next one, one lot remaining, 215,000. Sivdas Road, Freeport. No approvals. That hurts this country in several ways. Apart from the fact that it creates chaos in our system of land management, it creates chaos for the development process. Because when you apply for town and country approval, you are applying to be part of a development of a community in an orderly fashion. And town planners, like we have in town and country, and urban planners, the profession we're trying to create with the bill that's on our order paper, they're meant to examine things like the quality of the road and the availability of road network, the TNTech infrastructure, the WASA infrastructure, the number of persons, the health facility in the community, the number of persons it can accommodate, the school places, primary and secondary school places, access in and access out. And all those things are considered, something like garbage disposal. TT Post. There's so many persons in this country. I was earlier this year in Rio Claro for the launch of the Postal Code project, representing my former colleague, Robert Leigh Hunt. And I made the point about having dealt with those people who have properties that could be identified. What about all those persons who have built on the beach and up the hill and all over the place? How are we going to bring them onto the TT Post grid and give them a code and give them an address, and how could mail be deliverable to them? So that the absence, a simple thing as no town and country approval, must be something that is an offense that is punishable with a serious fine. So it is those ads that drew me to the work on this real estate agents bill. Because at a minimum, and the Honorable Attorney General and I discussed that in the Legislative Committee, at a minimum, this bill is not intended to deal with real estate developments or the sale of particular types of property and so on. It's meant to regulate the profession and the people who sell and the brokers and so on. But we felt at a minimum, we should use this bill to cause anybody who is doing any type of development with land to create a record. Because I would ultimately, as a citizen of this country, I would ultimately like to see that everywhere a parcel of land is being cleared, or a building is being constructed, or work is being done in relation to improvement or expansion, that a sign is erected containing the information relating to the approval of that by the municipal body or the planning authority, that we know the name of the contractor and the address and so on of the contractor. So if something happens to somebody in the area, we know who to go to. And all these particulars, you see, I always say we talk about Sweden and Norway, but we don't want to live like Sweden and Norway. We talk about North America, but we don't want to apply the same types of conduct that other countries do. So this no town and country approval is an aggravating matter. And when the bill was laid in the House, the other place, the Attorney General still was not, to my understanding, not satisfied with Clause 6, even as it was then, and an amendment was made in the other place. And what it does, it means that it does not matter if you're doing one lot, 5, 20, or whatever. The definition of simple development that we inserted in the amendment to the Facilitation of Development Act deals with a simple development being less than 20 lots. But this bill, in dealing with developer, and Senator Mark made a lot of it, simply deals with a developer is somebody who calls the subdivision of a large parcel into smaller lots, or erects building on land, or cause infrastructure. And that triggers a registration and a register created in the Office of the Registrar General that simply requires the person to set out some information, not as detailed as the real estate agent or the broker, but information that allows us to be able to at least identify who is doing the development. And that, my understanding of what the AG proposes to do, would lead to answer a point raised by Senator Deonarine, would lead to separate legislation governing the work of developers in this country. I think that is the next piece that the AG wants to work with, and also in dealing with that piece of legislation, to deal with the issue of marketing of real estate in this country. Because marketing, you would see as I get to the particulars that a real estate agent must provide, that would get to the words that I raised, mistake. Very often I have to deal with transactions where the property is the property that the person thinks they're buying and the person is actually buying is in two different parts of the country. You have mistakes, I'm talking about mistakes and not fraud, mistakes with the acreage. I spoke to somebody this morning who actually got an acre less than they bargained for in the first place. And if the more documentation an agent is required to put together at the start of a transaction, is the less problems we would have at the conveyancing stage, and most importantly, the less headache a buyer or seller will have after the transaction. So that is in relation to Clause 6, Mr. Vice President, and that is, thank you very much. The other area I wanted to go to, Mr. Vice President, is Clause 48, where we detail the particulars. So that is Part 8, Duties and Obligations of the Real Estate Agent. And it is very important. This is the sort of information that a solicitor will collect and record in a file. I don't know, Honorable Attorney General is a very, very young man, but I remember in my days before I went to law school, being sent to Basil Jack on the Harris Promenade. And Basil Jack had these beige files going right up to the roof. And then I was sent to Kelshall. And I saw likewise Kelshall had all these files because solicitors are required to keep all these documents because clients come 20, 30 years after. And very importantly, the real estate agent is supposed to have copies of the survey plans, valuation reports, title information, description of the property, the name and proof of identity of the parties, the commission, and copies of the relevant deed. This is the sort of thing that solicitors currently must maintain. But an agent should have all of these things to pass the correct information, but also have a record which demonstrates that what these parties are contracting for actually exists and they're reliable and verifiable, and this is important to me. 48. Mr. Vice President, I just want to say I do not agree. I dismiss outright this talk about part-time real estate agent. A real estate agent could be part-time and do a transaction for 15 minutes for the year and earn a commission that is more than an agent who is working year-round. So it's not a matter of how much time you spend on the job. The requirements of the law has to do with the fact that you are engaged in a part-time, in a transaction relating to land. And I want to say in response to Senator Deonarine that, A lot of things could be said. Every time I hear about a public office, I hear about lack of resources. So I heard about the Commissioner of State Lands, and I will tell you this. Commissioner of State Lands has law enforcement officers, contract officers, patrolmen, state land inspectors, clerical staff, administrative staff, GIS unit, IT people, agricultural assistants. Commissioner of State Lands, as I said in relation to the chief vet yesterday, has an array of resources that a minister does not have. A minister has a complement of 2 or 3 at the office. Some of these senior bureaucrats have hundreds of people. And all you can hear in relation to the conduct of the business of the people of this country is that we do not have enough resources. I do not buy that. And as I always say to the officers, do one thing with the resources that you have, and that would impress me. Mr. Vice President, I thank you very much.
Senator Baker.
Thank you, Mr. Vice President. As I join this debate, it's important for us to note that land is supremely important to many families. Land is an aspiration, and the acquisition of land and property are the things which families measure their contributions to their generations, born and yet unborn. And of course, land the world over has been and will continue to be the source of contention. This bill seeks to impose penalties for a range of offenses and stresses the importance of registering and licensing. There is a concern, and a valid concern, that it may seek to alienate agents at the lower economic levels, those that don't have the significant throughput of sales and business. There's a criticism that this bill has by practitioners in the field of real estate sales and marketing, is that it negates the time-tested training and industrial practice of apprenticeship and learning at the feet of a master in the industry. When you turn to the relevant clause of the bill, it speaks only, and I will get to that when I go through the contentious clauses, it speaks only to institutions that are accredited by the Accreditation Council of Trinidad and Tobago and other means of accreditation. Some of the sanctions in this bill are very excessive and they may do it with some revisiting. Now, there's another scathing criticism of this legislation in that it only seeks to oppress those that are attempting to follow the law. Whilst quarantining the behavior of the general public. So it's something that we want to look at. Each time we come to Parliament, we see excessive, we see increases, we see incremental and sometimes galloping increases in fines and sentencing prescribed in law. And we may want to revisit that to determine what type of society we may wish to build for our people. There's a very common criticism of this bill, and it has to do with the focus on attorneys. Attorneys as the panacea at the level of the licensing authority, and then, of course, without much regard to their knowledge in real estate and persons from other fields. I come from a community in South Trinidad, and there are 2 communities that I'm closely connected to. One is Point Fortin, the other is Point Appear. And in Point Fortin in particular, people speak of Tobago a lot. But in Point Fortin in particular, we suffer the legacy of colonialism. Because from this legacy of colonialism, when oil was found, the peoples were debarred the opportunity to own any of the lands around the oil. So what you have is a proliferation of squatting communities and that squatting should be in large inverted commas, because if I carry you to some of the places in Point Fortin that are deemed squatting communities, from Strikers Village, New Village, parts of Warden Road, Captiville, Parrylands, Gonzales, Cochrane, and you see the established communities that are there, the households that are there, the structures and systems of economic generation that persist, you would struggle to believe that till this day, that colonial disinheritance of preventing the democratization of land owning in Point Fortin and around the fields of South Trinidad in the oil belt persists till this day. This bill, however, does not seek to remedy that situation, unfortunately, because it's a narrow focus. But I'm saying that a real estate agent operating in an environment, just as we mentioned time without number, the peculiarities in Tobago, we need to look at communities in Trinidad, and a very important test case would be whether the legacy of the Petrotrin lands that were accumulated over different decades from the time oil was found till now, and the inability of persons to buy and own land in Point Fortin. The price of a plot of land being $500,000 for a modest plot in a community with little or no economic activity. So that's an issue that needs to be addressed there. The other concern that I have of this bill is the inability to address data dissemination. Now, residential and commercial real estate price indices, which starts at the level of the real estate agent and the transaction, whether the transaction be cash or be a transaction that engages financial institutions. This data can feed directly into a platform that can promote development of reliable, timely, and consistent statistics on real estate prices in Trinidad and Tobago. If we use this bill and include in it the requirement of real estate agents to provide, whether it be to the Registrar General's office or whether it be to the licensing authority, the transaction price of the properties that they sold, the times they were sold, the sizes of the properties, it would allow for anonymized data accessible and available to policymakers, which can help us in creating a house price index, a rental price index. It will allow for better assessment of risk for bankers. And of course, it would allow for more robust policy in affordable housing development across Trinidad and Tobago. Because what you will have is you will have a very clear picture using historical data, not of the current market values, but of the transaction prices of properties across the length and breadth of Trinidad and Tobago, creating a proper mosaic that gives information. I'm saying that this bill is poorer because it does not include this requirement of the real estate agents to provide this information in the first place. That is the transaction price of the properties. And secondly, to also accumulate this information at the level of the government in an anonymized form that can be accessible to researchers and policymakers. I'm sure the Central Statistical Office will be happy for this type of access and this type of advocacy that I'm making today. And I hope that this request falls kindly or is received warmly by the ears of the Attorney General. Now, and I will just end this plea with a simple story. When I was doing my MBA in finance, my intent was in the market that I was in to create such a similar register because my professor at the time did his for Scotland, in one of the towns in Scotland. And I was trying to do one for Accra and Ghana, which has a similar colonial inheritance to Trinidad and Tobago. And the information was, whilst available, the transaction prices, it was not accessible to researchers. So this transaction price information may be available, but it is not prepared in such a way that it can be accessible to persons in Trinidad and Tobago. And I wish to even go a further step. Many times, we have the requirement at the level of the bank or the real estate agent to engage the services of a valuator for properties. I am saying that whenever properties are so valuated, this bill should include the requirement for this valuation information to be processed in the form of a data bank so that it can be added to the anonymized. So what you get is real-time value of property, which can be compared against transaction prices, which is historical data. Now, when we turn to the bill, if we go to clause 11, speaking to the objection of registration, if we have a young or new, because new entrance into an industry can happen at any stage, and whilst we have reorientation of labor, someone can enter the real estate industry at the age of retirement, ordinarily. It doesn't mean that they have to be 18 years of age to be a new entrant. And regardless of whether they are young or they are ripe in age, the requirement that they may have to go through, if anyone or any persons object to them being a real estate agent, it should be done in a very timely manner. And I think the entire process should be capped in such a way that it may never be able to go beyond 1 month. So therefore, 1 month from when, not when the objection is made necessarily, but 1 month from when the application is made by the individual to become a real estate agent. No longer than 1 month must they be made to wait to understand whether or not, A, they are going to be rejected because of an objection placed against them, or whether they're going to be accepted as persons to be real estate agents. Now, so that's my recommendation regarding that specific clause. Now, regarding the association, I see on clause 22, subsection 2A, Roman I, it says one member who is a broker, 5 years experience in real estate business, Roman numeral 2, 5 years experience in real estate business, and 5 years experience in finance in Romans 3. Now, the number of persons employed in the financial services sector in Trinidad and Tobago, when you include credit unions, of which there are over 120, when you include commercial banks, when you include savings and loans companies, when you include money lending operations and so on, insurance companies, it's a large number of persons. It's in tens of thousands. And I think we would want to limit or put a caveat there that they should have some measurable experience in real estate finance, whether it be from the avenue of mortgage financing or insurance of properties and so on, so that it gives them an avenue to interact with valuations on a regular basis and an opportunity to interact with market prices of properties, and also the bevy of illegalities that can occur in the insurance services, in the real estate sector, so that they won't be naive. Now, turning to clause 29, regarding fees to the association. Just as the fees for a banker who is involved in mortgage financing has no issue regarding the fees for attorneys, because these are scheduled fees. The fees are clearly stated, so therefore, lawyer A or law firm B cannot circumvent those fees. They can't arbitrarily charge what they feel like charging. they have to charge as set down clearly in the law. I am suggesting that a schedule be prepared that can be updated from time to time upon recommendation between the licensing committee, Registrar General Office, the Association of Real Estate Agents, to be prepared to be birthed by this legislation. I think that a schedule, and I crave the indulgence of the Attorney General in winding up to see if such a schedule could be entertained so that we can protect persons who wish to be real estate agents from arbitrariness in any fees that will be so derived by the association. Then, if we turn to...
Senator Obika, you have 5 minutes.
Wow, thank you. That's a very short. Okay, so 20 minutes really runs out on you. Thank you, Madam President. So let me turn to clause 40, licensing of brokers. It just says a person of good character. I know we may take it for granted. Is this a police certificate of character, or is there any other mechanism? And if not, why don't we state police certificate of good character until there's a different certificate that is the standard that we go by? And the next part there on page 24, clause 40, section 5, Roman 4. It speaks only to the Accreditation Council. And again, I made the call for existing real estate agents who can, by virtue of whether it be an affidavit or by virtue of a testimony of existing real estate agent or a financial institution who've used their services, why can't we make an exception for those existing real estate agents who could display a proper track record without having accreditation behind the name? Because I'll give an example. There are many persons in the banking sector who have 30 years plus of banking, but their qualifications came through internal processes and courses at the level of their financial institution. But of course, new entrants would be required to have a bachelor's certificate, bachelor's degree, and in many cases a master's degree and other professional certifications. But the older hands and heads in the industry may have had different standards to matriculate via. So let's look at some exceptions for persons in the industry. I saw there on clause, well, on page 30, just to make it simple, a sales associate who acts as a dual agent. I wondered if there was an offense associated with that and exactly what would have been the penalties therein. When we turn to the disciplinary committee, it mentions an attorney at law, 10 years, no mention of a legal background, so there's something to look at there. And I'm suggesting that the disciplinary committee may want to include a banker, because I believe a banker, obviously, I've been a banker, it may seem that I'm declaring my bias, but I still believe that a banker would bring a lot of value to a disciplinary committee because we act as the intermediaries in the transaction. Now, in summary, the real estate agents, I need not add my voice to the protests of area or TTRE or whichever associations, because much of that representation was already made by speakers before me. So I want to return to my initial submission that the community in Point Fortin and other similar communities that have issues with land tenure, these things need to be addressed. Regarding the requirement of the transaction prices and the completed property valuations to be submitted to a body that would provide anonymized, accumulated data available to researchers, available to bankers, so that we have a property index that can inform policy making for affordable housing and inform risk-based assessment in mortgage financing at the level of banks, insurance companies, and will make for a more robust property market, as is important for the management of our gross domestic product and the development of our economy in Trinidad and Tobago. I thank you, Madam President.
Before I call on the Attorney General, I am now prepared to rule on the question of privilege that was raised by Senator Mark earlier in today's proceedings. Senator Mark alleged that the Minister of National Security deliberately misled the Senate, and in support of this allegation, cited the Minister's response to questions posed on May 13, 2020. Senator Mark also referred to a media release issued by the United States Ambassador to Trinidad and Tobago on May 19, 2020. Honourable Senators, I have carefully reviewed this matter. It is important to understand the chronology of events that led to this issue being raised by Senator Mark. The questions were posed to the Honourable Minister on May 13th, and he responded to the questions on said date. The media release was published on May 19th. Senator Mark, in raising a matter on the adjournment on May 19th, made extensive reference to the said media release. The Minister of National Security, in responding to the matter raised by Senator Mark, and in reference to the media release cited by Senator Mark, used the opportunity to explain his earlier response given on May 13th. The Minister also unequivocally stated in clarifying his response that he had no intention to mislead the House. It is well recognized that one of the key ingredients to be established when it is alleged that a member is in contempt on the grounds of misleading the House is that it must be established that the member making the statement knew at the time the statement was made that it was incorrect, and that in making it, the member intended to mislead the House. Speaker Carr of the Legislative Assembly of Ontario explains the issue quite succinctly. The threshold for finding a prima facie case of contempt against a member of the legislature on the basis of deliberately misleading the House is therefore set quite high and is very uncommon. It must involve a proved finding of an overt attempt to intentionally mislead the legislature. In the absence of an admission from the member accused of the conduct or of tangible confirmation of the conduct independently proved, a speaker must assume that no honourable member would engage in such behaviour. The Minister, having been provided with the opportunity by Senator Mark to elucidate on his previous statements made on May 13th, demonstrated via his response on the 19th of May 2020 that there was no intention to mislead or deceive the House. There is also no tangible, independently proved confirmation that it was the Minister's intention to deliberately mislead the House. Therefore, I rule that there is no prima facie basis to support a question of privilege. Attorney General.
Thank you, Madam President. Permit me, first of all, to express my gratitude to all honourable senators for their contribution in this debate. I think that we have covered a significant amount of ground, and certainly there were commendable suggestions coming from honourable senators. Permit me to also thank Senator Rambarat for joining this debate alongside my other colleagues on the government bench, but in particular him, because he provided a very fulsome dimension to the issues of developer, the next steps that we're looking at, and some of the cohesiveness of this law as it interoperates with other laws A, that we have passed, and B, those that are coming at us quite soon. Permit me, therefore, because the time is truncated, to adopt into my submission many of the submissions given by my colleague, Senator Rambarat. And yes, I acknowledge for the record that Clause 6 ought to be labeled the Rambarat Clause. That is the clause on developer. Permit me, Madam President, to now give some response to submissions from my colleagues, and I will start with Senator Mark. Senator Mark made the submission that developers ought to be treated with. Senator Rambarat has already addressed some of that. Senator Mark made some wild accusations about government ministers being involved in development. And I would like to say, first of all, that yes, many members of the Parliament, including opposition members, are developers. There was an acknowledgement by a very distinguished member of the opposition, Senator, forgive me, Member of Parliament for Tabakit, Suraj Rambachan, that he is in fact a developer, as I have declared my interest similarly on that point. That is not to say that the concept has been left out. Put quite simply, as Senator Rambarat put it, and permit me to put it in my version, it was critically necessary for us to capture a developer. We do not propose in this law to regulate by way of licensing developers. That is another subset of law that in fact we have already started perfecting at the AG's office. When we get back into the next Parliament as a government, we will be able to continue that work with certainty. There's a certain amount of consultation that we need to have, so we'll just allow for that process to continue. What I can say, Madam President, is that the concept of developers as we capture it in this, firstly by way of the definition in Clause 3, a developer means a person who erects a building or structures upon land, causes infrastructure to be built or installed upon land, or who causes the subdivision of large parcels of land into smaller lots of land. That's to capture everybody involved in any aspect. Because what we're dealing with in Clause 6, when we establish the developer, when we're dealing with a developer prior to erecting, causing infrastructure or subdivision, shall apply in the prescribed form to be registered. This allows us to capture a vast number of people who are simply breaking the law. Either they are not paying their fair share to the government of Trinidad and Tobago, or they don't engage in town and country planning, or city corporation planning, or municipal corporation planning, or WASA, or fire, etc. So it gives a positive mark for the first time in Trinidad and Tobago by way of compulsion of law that if you're going to be doing anything by way of development, that you will be known in the public registry as doing that. Can you understand how massively important that is? Because nobody has access to town and country planning to know who has been given town and country planning permission. Nobody has access to the city corporation. Of course, you have access under the Freedom of Information Act, but that requires you to go fishing and await a response. For the first time, we will have a public register available to the people of Trinidad and Tobago so that you know at any one point in time who is developing in this country. That impacts flooding, that impacts management of waste, that impacts land ownership. Are you building on state land? Are you not? And therefore, this simple Clause 6 is a radical transformation of Trinidad and Tobago as we understand it. Senator Mark looked at New Zealand, Jamaica, and Bahamas. He said they were not complex in arrangements. Yes, because they have a different system of land registration and development. So the Honorable Senator is not comparing apples with apples, or in our case, mangoes with mangoes, or indeed Julie mango with Julie mango, because there is a complete disassociation and disconnection with those models of law. What we did take from those models of law was the co-regulatory approach. A government in association with the association coming up with co-regulation. Senator Mark said that area ought to be included. Area is the private entity. I'll ask Senator Mark, well, why not TTREA? They have 200 plus members. Area has a membership. The point is, either one of them could have been brought in, but we would have a constitutional problem if we took a public law like this, with a public purpose set out in the functions, and gave it to a private entity. You see, area, as it has been incorporated as an act of parliament, was done by way of a private member's bill. And therefore, you cannot give public functions in law to a private member's bill. If you could, you would have to ask for constitutional exception. You'd have to go for a 3/5 majority. But you would have a serious problem in getting over the equality of treatment argument. Because now we have an entity, albeit only recently born, of the TTREA. And therefore you would be discriminating in law for people who are in similar circumstances, arguably. And therefore we cannot accept that particular recommendation. Senator Mark asked that the committee be broadened. He said that it was comprised of lawyers, and I'd like to explain why. Because the licensing committee issues licenses, and licenses are akin to property rights, because a license permits you to do something. To allow for that to pass constitutional muster, the people on the committee have to be protected by a service commission. The only service commission that is available in this regime will be the Judicial and Legal Services Commission. Number one, because of the independence of the Constitution, and number two, because it allows for lawyers to exercise the the quasi-judicial functions of granting a license or refusing a license. It's the same thing for the disciplinary committee. We have heard the recommendations coming for the broadening of members of the PAC, of real estate agents, of the industry to be included. Consequently, in clauses 30 and 54, we propose to move amendments to broaden the inclusion of stakeholders in the industry from 2 to 4 persons in both circumstances. That'll take us to 9 persons on each committee. Obviously, you have to go for an odd number, because if you went for an even number, you run the risk of a deadlock in law, and therefore you want to escape that particular position. Senator Mark asked, as did other senators, about the 3-year requirement to renew yourselves. Madam President, what time is full time?
3:51 and
Much obliged.
31 seconds.
Senator Mark and several senators asked about why have a 3-year position. Senator Sipasad said, for instance, it should be a one-time registration. We'd like to explain why. The Companies Act has shown us that if you have a one-time registration, the vast majority of people don't update their records because there's no need to, because there's no consequence. It puts the obligation on the registrar to look at annual filings, etc. But in this case, there are no annual filings. So you would not have the ability to know the currency of information. Is it up to date? Do you have the best information? And therefore, just like a driver's permit, which is cyclical in nature, or a passport, or the non-profit organization regime, we propose a 3-year renewal process so that you're always with current information. That is, of course, the best class in standard, and the Financial Action Task Force and many other jurisdictions have this way. We didn't think it appropriate to go for annual renewals. That would be too burdensome. Madam President, the allegation has come from several of the opposition senators that the Registrar General's office is swamped. Senator Deonarine correctly referred to something which I have spoken about many times in this Parliament. As Attorney General, I came in as Minister of Legal Affairs, spotted what I call the golden pot of information in Trinidad and Tobago. And what is that? The registry. Recognized that my predecessors did nothing to improve the registries. In fact, the software for the information management system for the land registry was operating on Windows XP on 12 daisy chain computers with no server, with no license. And in that environment, the system actually shut down. I don't know if you recall, but there was a point in time when the online registry was shut down and the industry was completely shut down. Literally, land transactions came to a halt in Trinidad and Tobago. Fortunately, as Senator Deonarine spotted, we have taken the property, business, real estate solution into hyperactive position. The property, business, real estate solution, underwritten by the IDB, is on version 3 right now. As the minister with responsibility, we have been test driving that system together with the legal fraternity for 2 years. Version 3, which is the final version, comes into effect in June 2020, i.e. next month. And the entire online system for filing, for geographic information systems, for land, for your maps, for your positions, every transaction that you can do in a lawyer's office, a deed, an agreement, all of that will be capable of online filing in final form by September 2020. That, therefore, takes us into all of the laws that we have done. We have spent time in the AG's office digitizing all of our deeds, hundreds of thousands of documents, and we have already brought forward the provisions to allow for electronic filing. We are already electronic managing birth certificates, death certificates, marriage certificates. We have stopped 15,000 people every 3 days from having to come to the AG's office, the Registrar General's office. We are light years ahead of where we were in 2015, and I thank the Registrar General for all of her excellent work together with the other agencies. We have done it. And as we go live, the Registrar General's office is no longer overburdened. And it is that same software that we are going to bring to save this country when we do the amendments to the registration of deeds package, because we're going to be allowing online filing. Sit in your office, upload your scanned copies, file it electronically, exactly as we are doing in the judiciary cycle right now. It was because this Attorney General passed the payments into and out of court legislation, and because this Attorney General passed the Criminal Division Act, that we are with an amazing judiciary led by the Honorable Chief Justice Ivor Archie, able to have all of the court documents being filed and stamped on an online basis. Yesterday we told of 1,450 hearings from inside the prison done by way of electronic facilities. Between the period March 16, 2020 to May 13, 2020, 1,450 virtual hearings were done from the prisons. So when Senator Hussain refers to an overburdened RG's division collapsing under a breaking position, that was the 2010 to 2015 version of the Registrar General. That was the Kamla Prasad-Bisesa-led government version of the Registrar General, not this government's version of the Registrar General. Madam President, with respect to the Code of Ethics, we propose that that is delivered by way of the co-regulatory approach. The Code of Ethics will be perfected between the Association of Real Estates under this law, together with the government, in the classic co-regulatory environment. We are looking particularly at the position of licensing. We had a recommendation coming from Senator Sipasa that sales associates should be licensed. We did not want sales associates to be licensed. We wanted them to be registered every 3 years. The only people that need be licensed are the brokers or brokerages. Why? They are the people who are handling the money. Now, there's this reflection upon receiving and handling money. Let me make it clear. The idea is that if the money passes through your bank account, that is what you're looking at. So picking up a check and delivering it to a lawyer or a financial institution is not handling the money. It is receiving and handling. Receiving must come first, and receiving in law means that you are encashing it into your own account or it's passing through money. We're relying upon the plain and ordinary meaning of law. Madam President, when we look to Senator Sipasad's inquiry about whether board members should receive remuneration, I'd just like to point out that none of the board members in the Law Association, the Engineers Association, the Land Surveyors Association, the dentists, the doctors, none of them receive remuneration because their association is intended to be operated on the pro bono basis of participation. That's very different from members of boards of directors. And therefore, we had to stand in parity with the example of other laws and how they operate. Madam President, when we look to, again, Senator Hussain made the point about area being represented. Well, that just can't constitutionally happen. We can't incorporate area into this law for the reasons I've offered. Again, Senator Hussain asked whether Cabinet can disagree with the persons appointed by the JLSC, and the answer to that is no. The appointment under this law in Section 30, Clause 30 and Clause 54 is that the members are to be appointed by the JLSC, the Judicial and Legal Services Commission. Madam President, Senator Hussain said that this bill would increase the cost of land transactions. No, sir, that's not what is on. We are regulating real estate agents to take away from the cost of corruption, to take away from the cost of money laundering, the cost of financing of terrorism. We know what that cost is. We saw the FIU tell this country that suspicious transactions and suspicious activities can be as high as $23 billion in 1 year. So the costs are not going to be driven up. But I'd like to remind Senator Hussain this. Real estate agents, in fact, earn, in some instances, fairly handsome remuneration, 3%, 7% commission. Lawyers operate on a scale of fees, which is in fact less than 1% of the transaction, and lawyers take all of the risk in the transaction because they investigate title, if we're dealing with the conveyancing aspect. So this is intended to reduce the cost to society. It is not in the case that you necessarily are going to drive the cost of transactions upward. Senator Diyal Singh asked about overseas companies. What happens when they want to purchase land here? Under the Foreign Investment Act, they would have to comply with those provisions. There's a notification by way of license if you're over a certain acreage, etc. So that law deals with that. Again, in answer to his position on developers, as Senator Rambarat has put on the record, we intend to deal with that separately by separate law. For now, developers must be known so that there's a methodology of tracing what they do. Senator Sobers asked again about costs. I've answered that particular aspect. Senator Sobers suggested that Section 16.5, Clause 16.5 was wide and it allowed too many persons to access the private registry. Let me repeat, 16.5 says financial intelligence unit, law enforcement officers, order of court, or any other written law. That's the same thing that we did in law for the Income Tax Act, for the Financial Institutions Act, for the Securities Act, for the Insurance Act, for the Non-Profit Organization Act. There are at least 5 examples in law that I can give to you right now where law enforcement as a matter of right ought to have the view of sensitive information or personal information, and that, as has been established in law, does not require any 3/5 majority treatment for the record. Madam President, Senator Sobers suggested that Clause 35B, termination of members of the committee for any other reasonable cause, was too wide. I respectfully disagree. Again, that is precedented in law as the formula that you use. In any event, if you have a dispute that you've suffered by way of termination for any other reasonable cause, you have the right of judicial review. You have the right of challenge for your dismissal. Let me give you an example. The situation with Joala Rambaran, the situation with Marcia Ayers Caesar, all went to court, and I need say no more than that. Madam President, Senator Diona Ryan raised the issue of sales associates being licensed, as well as handling of money. I've answered those positions in law as to why we treat with that. Look, Madam President, it's critical for us to remember a lot of people make their living in the real estate industry. We don't want to put burdensome provisions that, for instance, somebody who's working somewhere else has a part-time aspect of working as a real estate agent, has to go through a full licensing regime, because what we want to do is to allow the industry to carry its players forward. What you need to have is registration if you're a sales associate. Registration means there's notice to the world. The prescribed standards will be managed by the association itself in conjunction with the government, where you come up with what the standards are, what the code of ethics is, how you deal with the de minimis standards. But we want the association to prosper. We want the industry to be regulated so that it can grow, so that it's a sustainable profession. And it is by far the time, definitely, for us to agree that the real estate agents have done yeoman service to the industry of Trinidad and Tobago. They contribute 2.1% of the GDP of Trinidad and Tobago, and they deserve the dignity of being registered so that their profession is not seen to be a profession as a fly-by-night profession. You ought to have the dignity of your profession anchored in law, as this bill causes. Madam President, the certification programs do indeed vary, and that is something that will be dealt with. Some contemplation was also given to experience. I can tell you that that is something that the co-regulatory approach will deal with. Somebody who has been in the industry and has, by way of knowledge, experience, and practice. The old school solicitors qualified by being articled clerks, for instance, by practice and not necessarily by qualification. Senator Amin gave us a very good reflection as well. The requirement for misbehavior in office and bringing the office into disrepute. Senator Amin raised that inquiry. I would just simply say that that has been managed. It is a formula that we have used in other laws, and I want to assure the Honourable Senator that we kept this law in parity with the existing laws that we have. Senator Amin addressed as well TTREA and the deadline for registration of agents. I just tell Senator Amin those issues were in fact discussed with me by TTREA. Perhaps in your consultation you spoke with some of their members, but I can tell you that I met with their members on a Zoom meeting. We discussed these issues. They messaged me while you were speaking to say that they no longer hold on to that issue because they've agreed with it in the discussions that they held in consultation with the Attorney General's office. But I thank you for raising the point. Certainly, your consultation was genuine. Senator Obika raised a number of very interesting positions, and I want to agree with the Senator that the contribution to GDP, the anonymizing of data, the tracking of information will help us to deal with land prices, and land values. And I'd just like to also remind Senator Diona Ryan very correctly hit the point that the operationalization of the Registration to Title Lands Act, the land package, that is underway. The Senator is right. Coming out of that exercise, a lot of what Senator Obika mentioned, I should say, is part of what the government has done already. We are already on Trinidad and Tobago moving to a system of absolute title guarantee. As we bring that forward, what we needed to do, which will come up in debate next week, so I won't anticipate it, we needed to harmonize the system of registration of deeds with the registration of land under the RPA, the Real Property Act, because they are inconsistent. So we got to fix the existing system and then move our way forward into the Registration of Title to Lands Act.
Attorney General, you have
Much obliged.
5 more minutes.
So, Madam President, the property valuations, the property index, housing, the risk-based approach for the banking sector that Senator Obika has raised, I'd just like to tell him the government is way ahead on that trajectory. In fact, I can tell you that the Minister of Public Administration, who is Minister in the Ministry of Finance, the Honourable Senator Alison West, we have together settled a memorandum of understanding between the government of Trinidad and Tobago and the government of Estonia, where we are bringing in the government of Estonia to manage the data aggregation of Trinidad and Tobago into a best-in-class standard. That adds on to the property business real estate solution, which as AG I have managed to advance to June deadline 2020. It works in tandem with the amendments we've done to the companies regime. The companies database comes up in a matter of June 2020 as well. So you'll have companies, online filings, etc. As we move to this world of electronic transactions and data management, we get to certainty of data. Connect the dots. The real estate agents bill is tied in with the revenue authority, which is tied in with the property tax, which is tied in with the money laundering, which is tied in with the follow the money in civil asset forfeiture, explain your wealth, which is tied in with beneficial ownership, which is tied in with the registration of deeds reformulation, which is tied in with removing hidden ownership by secret trusts, which is tied in with the criminal justice system, which is tied into crime, which is tied into removing the proceeds of crime from drug trade or trafficking in persons, because people take the profit from crime and have to wash the money somewhere. And they inevitably wash it in three ways. One, with cash. Two, with companies which are fronts to real business. And three, with land purchase. And therefore, there is a web of connection in the government's agenda. When we pass one law on the left side, we also correlate with the law on the right side. For the first time, this country has an Attorney General's office where all of the laws are interconnected in the anti-corruption machinery, where all of the laws are connected in bettering the lives of our citizens of Trinidad and Tobago. And that is because of the combination of work between the Ministry of Finance, the Ministry of National Security, Public Admin, the Ministry of Agriculture, the Ministry of Trade. All of these ministries work in tandem with the Attorney General's office, and therefore we have one matrix to work with. Madam President, I genuinely commend this law to honorable senators. We propose to move amendments to clauses 9, 30, and 54 at committee stage, and I will ask for those amendments to be circulated. I genuinely look forward to the committee stage of this bill and welcome honorable senators' recommendations if there are any further ones, in particular those to be circulated, and I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Provide for the Registration and Regulation of Real Estate Agents in order to promote transparency, accountability and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estate agents, and to assist in the detection and prevention of money laundering and terrorist financing and other related matters, be read a second time. Those in favour say aye.
Aye.
Those against say no. I think the ayes have it.
Act to provide for the registration and regulation of real estate agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estate agents, and to assist in the detection and prevention of money laundering and terrorist financing and other related matters.
Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that a bill entitled the Real Estate Agents Bill 2020 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that a bill entitled the Real Estate Agents Bill 2020 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. The Attorney General's amendments are being circulated as we speak. Are there any, Senator Mark, are there any other amendments apart from the Attorney General?
We are having them typed up at this time, so.
Having them typed up.
Madam, we don't have resources.
Attorney General, you ready?
Yes, please. Awaiting Senator Marks.
No, we're proceeding.
We're proceeding?
And
Sure.
Senator Mark will, perhaps Senator Mark, you can indicate what clauses. Yes. Thank you.
Part 1, clauses 1 to 4.
The question is that clauses 1 to 4 stand part of the bill. The question is that clauses 1 to 4 now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Clauses 1 to 4 now stand part of the bill.
Clauses 5 to 7.
The question is that clauses 5 to 7 stand part of the bill.
The Attorney General, as it relates, it's 5 and 6, right, Madam Chair?
5 to 7,
5 to
yes.
7, right. Attorney General, the matter of clause 6, how you indicated that you will be bringing legislation shortly to deal with the licensing of developers. You can elaborate and indicate to us what is the name of this piece of legislation and when you anticipate its arrival?
Thank you. Madam President, Madam Chair, what I indicated was just after the general election when we returned to office that we would pick up that particular point. I really did say exactly that we would pick up this particular piece of position because it required consultation and it required a deliberate product. What I can say right now, Madam President, Madam Chair, is that developers who engage, if you look to the language of Section 6.1, erecting buildings or structures, causing infrastructure, causing subdivision, all of those are regulated already, but in disparate ways. Town and Country Planning, Lands and Surveys Division, WASA, Municipal Corporation, Ministry of Works and Transport, Fire, etc. All of these and of course, under the Planning and Facilitation Development Bill, there'll be some more harmonization. What we thought was unacceptable, what we think is unacceptable, is that you have to rely upon those information pots being secret or being hard to find. I said it in my wind-up, where we were looking at the Freedom of Information Act, really, to get that kind of information. So for now, what we're doing with the capture of a developer's register is to have a public registry that says, hey, I am a developer, and therefore it would cause the necessary interaction for scrutiny by whomever may be interested in the position. It's to give a central repository so that people would have better information of the positions.
AG, Madam President, I don't know if this is the right time to raise it. There's also a concern about the accessibility to the registry. that Senator Leida spoke about, in terms of it being available online, or if a person at present would have to come down to Port of Spain to request the information?
Under the Registrar General's Act and under the Electronic Transactions Act, all registers are available electronically. So as a matter of fact, the company's registry, the land registry, the birth registry, in some instances, they're all available online. What we're doing is that we're taking that further, if I could just assure you, under the Property Business Real Estate Solution, which goes into version 3 in June 2020, and which goes live, because we're going to physically be testing it together with multiple participants. Stakeholders are going to be using the system in the period June to September, and then everything will be online. But we've been doing that for over 2 years already. Yeah?
So, Honourable Senators, the question is that clauses 5 to 7 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 5 to 7 now stand part of the bill.
Clause 8.
The question is, that clause 8 stand part of the bill?
Chair, on a point of clarification.
Senator Mark, can you just speak into the mic a little bit, please?
Yeah. Yeah, I was making a point about, on a point of clarification, I would like to ask the Attorney General, all persons are required to be registered once they engage in real estate business. We are of the view that once you are registered, you ought not to have this process repeated every 3 years. Once you're registered, that should be for life. And you have a licensing arrangement that will take effect every 3 years, which we have no problem with. Would you want to consider a one-off registration rather than having somebody register every 3 years, as opposed to be a one-and-done one-off arrangement?
Attorney General.
Sure. I thank Senator Mark for the question. It's driven by practicality. It's driven by a number of positions. What we have observed, what I have observed as the Minister with responsibility for legal affairs, is that we have our registers filled with junk, meaning outdated information. People don't come in and give positive positions. And what we have noticed is very useful is when we put a repetitive cycle for registration and renewal, people come in with current information because you're putting the obligation on them to come in. The company's registry alone has over 20,000 defunct companies on it. And then we have to go through a painstaking process under the Companies Act to have them struck off and hunt down people. And that causes immense abuse of resources and also opportunities for fraud. So in the circumstances, we took the model from the non-profit organizations law, which we just recently passed, and we kept to the 3-year renewal process because it would better our chances at having information current and therefore easily accessible.
Attorney General, we renew our driver's permit every 5 years or every 10 years, according to age. Could we look at having a longer period? I understand the rationale for not having it for life, the registration for life. Could we look at a longer period than 3 years?
May I? Yeah, so I welcome the suggestion. We sought to harmonize it with the non-profit organization, but really and truly we also sought to take advantage of the fact that we know the PBRS system is coming. And in the PBRS system, and with the company system, I didn't get to say this, we purchased and installed a brand new company's registry. So the company's registry had fallen into disuse, it was out of license, etc. So we took the provider for the birth registry, Births and Deaths, which is Axial, it's a Canadian company with Australian ties as well, and we brought them in to do the company's registry. They have already installed all their hardware, migrated data, and we're going to go live with a brand new company's registry in June of this year, all things being equal. That means that the re-registration process, which is a filing of a company-type document, can be done online. In fact, Madam President, I propose to bring a miscellaneous provisions bill in the next week or two, which will allow us to put that into law so that we can do e-filings on these bases. So I understand the Honourable Senator's inquiry, the ease of doing business in many senses, but we believe that we have an IT solution to manage that.
So, Honourable Senators, the question is that Clause 8 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 8 now stands part of the bill.
Clause 9.
The question is that Clause 9 stand part of the bill. Attorney General, your amendment.
Yes, Madam President, Madam Chair. Madam Chair, we had a recommendation come in from the stakeholders that we were being unduly restrictive in subsection 2. So subsection 2 says, subject to 10, a company or partnership may be registered as a real estate agent upon satisfying that its directors or partners, as the case may be, wholly prescribed qualifications. Now, under the Companies Act, Chapter 8101, you have to have a minimum of 2 directors. So that means that we will be obliging both people to be registered in the real estate industry, and the sensible recommendation that came in, I believe it was TTRE that asked for this, they said, some of us have investors, and one of us is the agent, and the other person may just be a director. That had some compelling factors inside of it. So what we propose to do is to amend subclause 2 and instead say that we only needed at least one of its directors or partners, as the case may be, to be registered under the Act. So that way we didn't unduly shrink the industry by having both the directors or both partners as positions of license. So that's the rationale, Madam President, Madam Chair, for the amendment proposed and circulated to Clause 9.
Interesting, because TTR, whatever that organization is that the reason why you are doing it, or there is some other reason in the public interest you're doing it?
Well, I just explained that. The reason in the public interest is that at law, to have a partnership, you need 2 people. Under the Companies Act, you have to have a minimum of 2 directors under the Companies Act. The industry, the public interest is that you may have companies where you have an investor, somebody else, and only one person who's performing the real estate function. So that one person as a director should be qualified, but the other person doesn't necessarily need to be. So it is purely public interest. It doesn't matter who said it. It may very well have been Area who said it. I just can't remember who said it. But the point is that there was merit in the submission that if I said both partners, or if I said directors, it meant that everybody had to be qualified. And as you know, sometimes boards of directors are comprised with external persons where you want to get an outside perspective. It would be unduly restrictive to ask all of those external people to be real estate agents or sales associates.
But AG, this does not cater for companies to be registered as agents.
Yes, it does.
Only individuals. So in this case, when you're saying you're asking for only like a director or one person.
So, Madam Chair, Clause 9 says, subject to 10, an individual may be registered as a real estate agent upon satisfying that you're 18, individual meaning a natural person, and you have the qualifications. Subject to 10, a company or partnership may be registered as a real estate agent upon satisfying that its directors, now we're going to say at least one of its directors or one of its partners, as the case may be, may hold prescribed qualifications. So subclause 2 allows companies and partners.
Okay, so now you say you only want one director or one of the partner to be qualified?
Yes.
Okay, thanks.
Yep.
The question is that Clause 9 be amended as circulated. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The question is that Clause 9 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 9 as amended now stands part of the bill.
Clauses 10 to 12.
The question is that clauses 10 to 12 stand part of the bill. The question is that clauses 10 to 12 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 10 to 12 now stand part of the bill.
Clause 13.
The question is that clause 13 stand part of the bill. Senator Mark, you have proposed an amendment.
Yeah, that's something. Senator.
Senator Hussain.
Thank you very much, Madam Chair. Through you, Madam Chair, Attorney General, I'm looking at sub 4, 13 sub 4, with respect to the particulars of the register of real estate agents. We believe also, AG, because the sale associates will fall under the brokers in terms of supervision, whether or not we would also want to include a particular in the register for all of the sale associates that would be supervised by a particular broker.
Another aspect of the amendment, Senator Hussain.
Of the amendments, please.
3G. You're asking 3G for registration and in there. So date of renewal of registration. You're asking for to remove the words registration and. So you're going date of renewal
Yes.
of license.
Yes.
Yeah, it's
Yes,
self-explanatory.
Because, Attorney AG, our position from the second reading of the bill was that we were asking that the persons who are persons engaged in real estate business, they just register once, just like the law association,
Understood.
and then we have the license alone that is being renewed. Hence, that amendment is prompted in 3G.
Yeah.
That is our policy with that. And then the other one is what I just explained in terms of including a particular with those sale associates.
Understood.
Yeah.
Yes. So thank you, Honorable Senator. I understand the rationale for the proposed amendment to 3G. Our policy is for the renewal of registration. So we respectfully don't accept the removal of registration and because we want, that will be a cyclical position. In subclause 4, in subsection 4B, the request to supervise sales associates, to list that, it actually came in the House where Dr. Tiwari raised the issue as well. And the rationale that I gave him then, I give now, which is because sales associates move from transaction to transaction at each time, we found you may find yourself with sales associates listed now who are not going to be sales associates next day or the day after. Because we had the registration of all sales associates on the public register, we wanted the brokers just to describe themselves because the industry practice is that it's really very fluid. People just come on and come off for transactions from time to time. So I understand the reason. It's commendable, the thought, but the industry practice lends itself to a difficulty in having that registration. They'd have to file changes on a constant basis because the person came on and came off in those circumstances. So if I may respectfully, for those reasons, not accept the recommendations to clause 13.
Honourable Senators, the question is that clause 13 be amended as circulated by Senator Mark. Those in favour say aye. Those against say no. I think the noes have it. Honourable Senators, the question is that clause 13 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 13 now stands part of the bill.
Clauses 14 to 17.
The question is that clauses 14 to 17 stand part of the bill. The question is that clauses 14 to 17 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 14 to 17 now stand part of the bill.
Clause 18.
The question is that clause 18 stand part of the bill. Senator Mark?
Yeah, Madam Chair,
Senator
again,
Hussain?
we had raised the matter of the period. First of all, we believe that registration should be a one-off. The AG is saying the policy of the government is not one-off. We are saying, and that is why we had proposed the removal of the 3-year period of registration. So we'd like to ask the AG to consider that again, or reconsider that.
Attorney General?
Madam Chair, I've already offered the government's rationale for explanation, so I respectfully decline the invitation.
So, Honourable Senators, the question is that clause 18 be amended as circulated by Senator Mark. Those in favour say aye. Those against say no. I think the noes have it. Honourable Senators, the question is that Clause 18 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 18 now stands part of the bill.
Clauses 19 to 21.
The question is that clauses 19 to 21 stand part of the bill.
Again, Madam Chair, once a member of the public, in this instance a registrant, is unhappy.
May I ask what clause, Senator Mark, you're dealing with?
Is 19 we're dealing with, right?
We're dealing with 19 to 21. So clause
Yes,
19,
so I'm dealing
yes?
clause 19, right?
Yes?
Where the person, in this instance a registrant, would have to, if he or she is not happy with decisions taken by the Registrar General on the issue of renewal, then the person will have to take his matter directly to the High Court. And I said in another debate that we should try to create a mechanism to avoid people from going to the High Court if they are not satisfied with the level of redress at this level. So I'm asking the Attorney General whether we can look at some mechanism here that would permit people to avoid expenditure that is sometimes, or expenses that might be beyond their reach at times.
Attorney General.
Madam President, we had a long discussion on this on a different bill yesterday, and I do understand Senator Mark's submissions. The experience, as Senator Vera in fact reminded us yesterday, is certainly one that tribunals sound good in theory, but they're actually perhaps more expensive than actually getting to court. The harmonization that this law proposes is with the Companies Act, the Non-Profit Organizations Act, etc., where any aspect of refusal under the existing Companies Act actually goes to the High Court. That has worked extremely well in a manner that has no difficulty and no real problems in terms of costs, etc. And for the sake of harmony and also for the policy that the court is the best position, we respectfully believe that it is properly drafted the way it is.
So, Honourable Senators, the question is that clauses 19 to 21 stand part of the bill. Those in favour say aye. Aye. Those against say no. Clauses 19 to 21 now stand part of the bill.
Clause 22.
The question is that clause 22 stand part of the bill. Senator Mark, you have circulated an amendment. Senator Hussain, Senator Mark. Senator Hussain.
Thank you very much, Madam President. Madam President, this particular amendment deals specifically with the composition of the board of the Real Estate Agents Association. We believe, Madam President, that there should be some more representation on the board in terms of having 2 members who are brokers, and also the other amendment will deal with the experience from 5 years to 10 years, simply, AG, because we're trying to establish an association that has some very experienced members at the executive level who would be able to guide the policy of the association, seeing that they have now been given a lot of responsibilities in terms of a long list of what the association can do that is found at clause 24.
Attorney General.
I thank the Honourable Senator for it. This is actually something we wrestled with, the years of experience. Well, if I may deal with the first point first, because the first submission is to change the word member to persons, because in clause 27, as it really reads to this, we're actually having mandatory membership. We want these people to be members, so it must come from their flock. So if I may respectfully not accept the recommendation for the change from members to person, for the reason that there's a mandatory membership, just like the Law Association has a mandatory membership. With respect to the number of years, 5 years or 10 years, we had long discussions with the stakeholders in particular. And the fear was that there's actually a small amount of people who could meet the 10-year category. And what they wanted was, in the event that they didn't have the membership with that number, that they wanted, in fact, the lower bar of 5 years. I think that as the profession grows, certainly an amendment is going to be required. So like the Law Association, we get to senior ordinary member and junior ordinary member, but we're not there yet, particularly because people for brokerages or brokers have to go through a licensing regime which requires qualifications, and then there are qualifications that have to happen by way of academia. So we may find that the 5 years is hard to achieve as it is, let alone, because I don't know how many people have the academic qualifications now. That's why we're waiting on those prescribed qualifications to be developed in coordination with the industry. The government doesn't pretend to know the industry as well as the industry does. As Attorney General, I have a perspective on the industry, certainly from my years in conveyancing and mortgaging and in corporate law. I have a very good perspective, but that's as an attorney at law. So for those reasons, because of the pot perhaps being too small at the 10 years, as we now start this law, we wanted to stick with the 5 years.
Just for the record, I would just like to say, Attorney General, that this particular amendment was because of consultation I had with some members of the industry. Hence, that it was brought that we increase the years of experience. So it's not my amendment per se, but it's born out of the consultation that I had with those
Madam
members.
Chair, if I could just quickly say, I fully well understand that, Senator Hussain. I didn't mean to come across in any other way other than welcoming the suggestion.
What role, if any, do you envisage for the current organization called AREA as it relates to this piece of legislation in the context of Part 4, 21, to the point that it's 21 to whatever one we are dealing with? Do you have any role for this organization, or you think that organization is just going to become extinct?
Attorney General.
Sure. So, Madam Chair, we actually met with AREA for over a year and discussed, because they were the first promoters together with the AG's office, and they really engaged in a most amazing way, if I may, Madam Chair, thank profusely, in particular, Mr. Mark Edgill, who really championed this particular work together with his predecessor at the helm of AREA. The difficulty we have in incorporating AREA is that we would collide with the equality of treatment aspect, because AREA is not the only association. It's been a recent association born. But the point is, whether they're young or they're old, there still is another association. What is intended here is that all of the real estate agents will come into the system by way of registration. They will therefore become persons who are mandatorily required to be members of the association, because Section 27 of the Act will provide for that. Those members will then convene a meeting. It's set out in the schedule how the first meeting is done, and by popular vote will vote whomever they want into, exactly as we do for the Law Association when we have our meetings to elect the executive of the Law Association, or the Dental Council, or the Medical Council, etc. So this is really to preserve democracy in the equation. How they arrange themselves, how they lobby, how they manage to get in is entirely up to the membership of the Real Estate Association. That's up to them. So they would have that responsibility.
No. Madam Chair, how is this association in the legislation going to be funded and financed in terms of operations? Because
I understand.
If I may,
sure.
Just be ahead of time. They are asked to provide secretarial services for two committees, the disciplinary committee and the licensing committee. So I'm asking you, where are they going to get the funding from for this?
Sure. Very valid question. They get the funding from themselves by way of their payment of fees for subscriptions for membership. The Law Association has its fees for membership. The only board that I have come across ever that has the bill paid for by the government is the land surveyors. And the reason is because we found it very anomalous that the land surveyors were underwritten by government, is because the vast majority of land surveyors work for the government at the Commissioner of State Lands, Lands and Surveys Division. Every other board, medical, dental, engineering, and lawyers in particular, demonstrate that they more than have the ability to afford their affairs. In the case of the attorneys at law, for instance, they have that much money they could have bought their own premises, their own buildings, their own structures. So it can be self-funded.
Is it going to be government or is it going to be?
It'll be up to the association.
Association.
Yeah.
So, Honourable Senators, the question is that Senator Thompson,
Yes. Are you still on 22-2?
Yeah.
I am on clause 22 dealing with Senator Mark's amendment.
Yes, because I was looking at the one with the years, the number of years, 5 and 10, because I wanted to suggest, because I myself find 5 years experience for the attorney at law is a bit low. If we could find a middle road, find the average between you, Mr. Attorney General, and Mr. Hussain, and say 7 years. I'd be more comfortable to have 7 years as a broker and 7 years experience, you know, rather than the 5 years that you seem to like.
Attorney General.
So
We work with that?
number one, from a precedent point of view, we go in brackets of 5 and 10. Number two, the problem with the brokers in particular is that, remember, this is virgin territory. We're now going to have a licensing of brokers for the first time, and therefore the clock starts at 0. And therefore it's going to be extremely difficult potentially to even find somebody who meets 5 years as it relates to the brokers. We've gone for the 5 years because if we look to the concept of a magistrate, the qualification for a magistrate is 5 years experience. A judge is 10 years experience, a master is 7 years experience. So we're looking at it from the precedent point of view at 5 years, and particular to keep it in parity with the brokers at 5 years, because we're starting at the clock at 0, and as we press the start, we then get the years moving.
You would have done your homework.
Yeah.
And you are therefore able to say how many brokers have in fact 5 years before you decided to put this in the legislation?
Yes, of course. We can, for instance, already refer to the fact that, forgive me, I think I have. So let me pull it up. I can tell you, Madam Chair, in the bracket of area alone, area has several brokers registered with them. They have 48 corporate entities, 167 sales associates, 215 members, and if I'm not mistaken, they had about a certain number of brokers. I can't find it on my phone just now, but we have brokers. The problem inside of this is when you get to the provision that is for the licensing of brokers, when we get to that part, the prescribed qualifications have to yet be managed. That's why we put in clause 83 to allow for the 12 months and 18 months for brokers. So we're not quite sure where they're going to draw the line on brokers yet, who's qualified and who's not. That's up to the association to do those things, the committee to do those things. In those circumstances, to raise the bar too high at present may unwittingly cause us to lock people out. So even though there are a number of brokers right now, these brokers as quote-unquote qualified means what? There are no qualifications for brokers in Trinidad and Tobago right now, legislatively. It's an ad hocism. It may come from the US, it may come from the UK, they may be just a number of years of practice. They style and call themselves brokers, but they're not really in a standard of being a broker. So that comes about when the licensing committee says what the qualification for a broker is as we come further into the bill. So for those reasons, we prefer to stay at 5.
But you know, the question of qualification and so on would not really impact the number of years, because you're still looking for people. And you have started off by talking about the importance of this organization. Yeah. So that, that's why I suggest that the 5 years is a bit low. Because you have said, you know, that it's a lot to do with money laundering and detection and terrorist financing. These are heavy matters, you know.
So may I ask you, what is a broker?
Sorry?
If I ask it this way, who is a broker? What is the qualification in Trinidad and Tobago for a broker right now?
The fact is, whether you define them or whatever, you are going to be looking for persons of certain experience.
Yeah.
Right? whatever the nature of the experience, something that you can determine afterwards. So the number of years that you're in the particular business that you consider important can determine who is a broker is not the same kind of question you're asking. You see? So
Yeah.
all we're trying to do is to find a middle road with something that people are comfortable with.
So unfortunately,
So I prefer, the fact is, I prefer 7 years, and I'm telling you, I prefer 7 years rather than 5 years. I'm more comfortable with that. Whatever you determine it to be, the qualifications to be.
Attorney General.
Madam Chair, my difficulty is that I don't know what the qualifications are. So because I don't know what they are, because the industry will settle that in due course in a co-regulatory point, to put it at a higher level may be problematic. So we prefer to start at 5 years because we have yet to crystallize what the qualifications are. There are no qualifications at law right now for brokers. So under the Legal Profession Act, we know you need to have a LLB, you need to be called to the bar at the Hewarding Law School, or under the 6-month regime, we have certainty of qualification. There is no certainty of qualification for brokers at present right now. So,
Attorney General, I think Senator Mark wants to raise something.
yes, please, sure.
Senator Mark?
Yeah, I would like to support Senator Hazel Thompson. I hear on this. I think the AG is sometimes, when he's making his argument, he's saying that we have not set the qualification bar. But you have a lot of people outside here, and he hasn't been able to find on his phone the number of brokers that has 5 years experience, 10 years experience, 15 years experience. So I think it's an eminently reasonable proposal. We had proposed 10 years because we felt that this is a very important industry. And this 5-year experience was too low. And if, for instance, we are trying now through the submission made by Senator Thompson Ahi, that we should try to find a middle road. I think the AG referred to a magistrate as having 70 years experience. No, you talk about somebody, a master, having 7 years before they become a master. So I think this is an eminently reasonable proposal.
Sure.
And if the Attorney General doesn't want to give in, can I propose an amendment?
Well, you have an amendment before us right now. Attorney General, hold on one sec. Attorney General, just respond, and then we will treat.
Sure.
If you want to further amend, Senator Mark.
So, Madam Chair, I understand the wisdom of saying let's go for a higher bracket at 7. I do. I genuinely thank senators for that recommendation. It's not that I'm just refusing for refusing's sake. If I may just make it clear. When we get down to clause 40 of the bill, licensing of brokers, and we get to 40 subsection 5, Roman 4, has satisfactorily completed such training in real estate business with an institution accredited by the Accreditation Council, or such course in real estate business recognized by the Accreditation Council as the committee may approve. Then we get to Roman 5, has satisfactorily completed such additional training with an institution accredited by the Accreditation Council as the minister may, after consultation with the association, approve. And then when we get down to clause 83 down in the bill, and we look to the transitional provision, what this does is to say that the committee is going to, in the consultation with the Real Estate Agents Association, the committee is going in a consultation to decide upon what the qualifications are. These are not cast in stone now. They're going to be formulated in the road ahead. And when made certain, the risk in law is that we may be with a very small bracket of people. The number of people in Trinidad and Tobago who call themselves brokers right now, or who call themselves real estate agents right now, it's just that they call themselves that. It's like somebody calling themselves a journalist. We had a court recently decide upon whether somebody was a journalist of convenience or not, just as an example. So the problem we have is that there is no present qualification as to what a real estate agent is, what degree you need to have, or course, or experience. That must come out organically from the consultation with the industry. The industry must decide, look, I've been in this business as a real estate agent for 50 years, but I don't have education. Anthony N. Sabga, who founded the Ansamakal Empire, had primary school education, full stop. But nobody could dispute that he was one of the geniuses of this country. So we need to leave room for the industry to decide for itself what the qualifications are. Senator Karim in the House raised the point of life experience, and he was right that it's a certifiable thing. That's why in my wind-up I referred to articled clerks. So you did your articling to qualify as a solicitor, but you didn't have to go to a university to do that. So because of those things, I could say 9 years, 7 years, 4 years, 3 years. I don't know what the qualification is yet. That's an exercise to happen. So it's not that I'm being obstinate in refusing genuine, meritorious suggestions from Senator Mark or Senator Thompson, i.e., it would be imprudent as the drafter of law for me to now draw a line in the sand where I don't know what the product is.
So, put the amendment. Is it that you want to further amend?
Before I propose a further amendment from 10 to 7 years as a compromise solution, I would like to ask the Attorney General, through you, based on my own consultation. No, I just advised them that Reutech has a course, a 2-year course in brokerage that many of the same brokers have attended. Now, I don't know if Reutech is affiliated or is accredited by the accredited council.
Yes.
And therefore, I don't think it's fair to just dismiss, say that there's no qualification.
So, Senator Mark, at this stage,
So I'm proposing, Madam Chair, with your leave.
I have your amendment. You're further amending, changing 10 to 7.
Yeah, I'm supporting Senator.
Honourable Senators, the question is that clause 22 be amended as circulated by Senator Mark and further amended by deleting the word 10 at B and substituting the word 7. Those in favour say aye. Aye. Those against say no. No. So it's 4:35. At 4:38, we will commence the division. I would ask that all members return to the chamber to vote. Yeah, she could start. Okay. I will restate it. So we are about to commence the division. Honorable Senators, the question is that clause 22 be amended as circulated by Senator Mark and further amended at B by deleting the word 10 and substituting the word 7. Those in favor say aye. Those against say no. No. I think the noes have it. Honorable Senator, no, division now.
Mr. Khan? No. Mr. Khan? No.
The question is, Honorable Senators, we are voting on the amendment put forward by Senator Mark and further amended.
May I ask a question, please?
Yes?
I fear, because I, unlike you, have the experience of going downstairs, I fear that senators present here may not know what they're called upon to vote on. And
No.
on that, no, I'm seeing a yes coming from Senator Vera across there. Maybe, I don't know.
Attorney General, just
Yeah.
1 second. Members are supposed, if you are out of the chamber, you can follow the proceedings in all the various ways that you can follow the proceedings when you're out of the chamber. There is a list of amendments circulated by Senator Mark. We are dealing with clause 22. The amendment is further amended at B to delete the word 10 and substitute the word 7. We will now commence the division.
Mr. Khan?
No.
Mrs. Goofy Schoon? No. Mrs. Batiste Primus? No. Mr. Rambarat? No. Mr. Moses?
No.
Ms. West?
No.
Ms. Cox? No. Mr. De Freitas?
No.
Mr. Singh?
No.
Dr. Henry?
No.
Mr. Dookie?
No.
Mr. Williams?
No.
Mr. Mark?
Yes.
Ms. Amin?
Yes.
Mr. Hussein?
Yes.
Mr. Obika?
Yes.
Mr. Leiter?
Yes.
Mr. Richards?
Abstain.
Mr. Vera?
No.
Ms. Yurang?
Yes.
Ms. Sipasad?
Yes.
Mrs. Thompson-Aye?
Yes.
Dr. Remy?
Abstain.
Ms. Phillips?
No.
Mr. Drayton?
No.
Honorable Senators, the result of the division is as follows. 8 members voted for the amendment, 15 voted against, and 2 members abstained. The amendment, therefore, was not carried. The question, therefore, is that clause 22 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 22 now stands part of the bill.
Clauses 23 to 26.
The question is that clauses 23 to 26 stand part of the bill. The question is that clauses 23 to 26 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 23 to 26 now stand part of the bill.
Clause 27.
The question is that clause 27 stand part of the bill. Senator Mark, you have an amendment. Senator Hussain.
Thank you very much, Madam President. Madam President, this amendment to clause 27 of the bill deals with who will be recognized as a member of the association. Now, AG, based on your model that you proposed, that you have the registration having to start over every 3 years in terms of renewal, this again was based on our policy, one-time registration, renewal of license. So we're saying that if we had proposed that model and had you agreed, it would have now been that a person would have had to hold a valid license in order to participate into the voting and any other things related to the business of the association. So that is the amendment that we propose here in terms of qualifying who becomes a member, that they should also hold a valid license.
Attorney General.
I thank Senator Hussain for such a clear explanation. I certainly understand his point of view. We've put that question already about whether one should have a one-time registration or the renewal of registration. From the government's point of view, we are recommending the renewal of registration every 3 years, A, to keep it in harmony with the non-profit organization regional approach, B, to take care of the disaster that the companies law is, where we don't have companies with up-to-date documents because there's no mandatory position, C, to keep it along the lines of things like driver's permits or passports, etc., to make sure you're dealing with the right people at the right time, and to avoid a deregistration exercise, which the registry would then have to do, which is like searching for a needle in a haystack. In this case here, clause 27 is literally 2 lines long, but it is the heart and essence of this entire bill, really. This is the clause for mandatory membership. This is the clause that makes it all work, literally. So I do understand Senator Hussain's point of view. It was premised upon something that we've spoken on already. The Honourable Senator was careful to say that, and may I respectfully decline the invitation on this occasion.
Chair, before I take my leave for social distancing, I just wanted to ask the question. There are cooperatives that are engaged right now in property development. Point Cocoa Agricultural Cooperative Society in Granville is one. There is Rancho Quemado, and there are a couple others that are set up for the sole purpose of developing property and selling to their membership. Would there be any ability of the cooperative itself to join the association, given that the members themselves may not perform the function of an agent until the times the cooperative decides to divide property among its members?
So, Madam Chair, Senator Obika's observation is dealt with under Clause 6. So Clause 6 is where we have the register of developers. If the cooperative is engaged in the marketing arrangements in the manner that we capture in Clause 5, which is the business of real estate, well, then you may very well find yourself open to registering yourselves as a real estate agent, because there's nothing to stop anybody from being registered as a real estate agent. You can apply via the form, get the prescribed qualifications in gear, and therefore legitimately call yourself a real estate agent, as a sale associate or a broker, whichever way you want to go. But we had sought to capture the cooperatives, the part owner dealing with himself in those arrangements in the developer's context. Because what Senator Ramrat correctly said, that's a whole industry that needs to be developed by itself. The self-organization, the part owner, because they really fall within the definition, they fall in Clause 5.
Another type of organization, those are the property management agencies that deal with rental of properties and so on. How are they to be captured?
So they are captured, Madam President, Madam Chair, forgive me, they are captured in the earlier sections. So when we're looking at, so the part owners are caught, that's where the cooperative societies will come in, not so much as developers, right? They are caught under Clause 5, 2, D, where you're dealing with property of which you are an owner or part owner. When you're dealing with developers, it's subclause E, and the register of developers. And developers can potentially also capture the cooperative that Senator Obika just referred to. Senator Obika, would you mind just reminding me the other question that you just had?
The other would be the companies that are involved in property management. So, for example, they rent properties.
So that is captured in the definition of what real estate is, practice of real estate. If you look at it, engages in property management, either as a consultant or as an agent, takes part in procuring, advertising wholesale, directs, assists. And when you looked up the definition of property management, which is in clause 2 or 3, whichever one it is, property management is defined as, it's at page 4 of the bill, or my page 4. Property management means overseeing real estate owned by another person, etc. So we capture it in the definition section properly. Yeah?
That clause 27 be amended as circulated by Senator Mark. Those in favor say aye. Those against say no. I think the noes have it. The question is that clause 27 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 27 now stands part of the bill.
Clauses 28 and 29.
The question is that clauses 28 and 29 stand part of the bill. The question is that clauses 28 and 29 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 28 and 29 now stand part of the bill.
Clause 30.
The question is that clause 30 stand part of the bill. Now there are two sets of amendments. One circulated on behalf of Senator Mark, one circulated on behalf of the Attorney General. We'll treat with Senator Mark's first. Senator Mark. Senator Hussain.
Thank you very much, Madam President. Madam President, this particular amendment deals with, firstly, the removal of the minister in terms of the nomination of the persons in the real estate business to form part of the licensing committee. We found it better that the minister should be making the appointment on the recommendation of the association, because it's really the association will be the representative body of the real estate agents. So that's the first amendment that we proposed. The second amendment is that we also would like to change the composition of the committee, and this brings us back to the same point that we debated earlier, with having two brokers and each having 10 years experience in the field of real estate business. And they also will be nominated by the minister on the advice of the association. Thank you.
Attorney General.
Thank you, Madam Chair. Madam Chair, this inclusion of minister in subclause 2E. So first reference to minister is a person with experience in accounting, finance nominated by the minister. E is two persons having at least 5 years experience in real estate business nominated by the minister. Now, here is the heart of this entire position. This concept of real estate agency management in every jurisdiction where it's successfully done is done by way of co-regulation. Let me repeat that. Co-regulation. Because it affects the state, but it affects the industry as well. What we did is we birthed the concept of the association. We just dealt with that in part 4, sorry, in the provisions earlier. That's coming before section 30, clause 30. In the association's composition, they organically look after themselves. They comprise themselves. They run their business, they come up with their stuff, they maintain their standards, they have full input. When we get to this clause 30, we're talking about the real estate agent's licensing committee. There is a risk and danger in himself to himself. And because in the real estate industry, when you're treating with these issues, you have to have a co-regulatory approach. The minister, i.e. the representative of an executive or a government, has to have a role. So the only place that we put the concept of a minister coming in is in the two committees that we're dealing with, one for the disciplinary committee and one for the licensing committee. But we are very careful to fetter that executive involvement by ensuring that the people that have command of these committees, in Clause 30 here we're dealing with the licensing committee, the people with command of these committees are appointed by the Judicial and Legal Services Commission, not by a government. So the core regulatory improvement anchors number 1 in Clause 30, which is what we're looking at here. It's for those reasons that we've put minister. If we were to put in the recommendation that it's on the advice of the association, well, then there's no more correlation. The core regulatory aspect does not include any aspect of government. Because you got the JLSC, you have the association, but there is no state enterprise inclusion. And the state has to be involved because we're looking at the effects of the industry upon financing of terrorism, fraud, money laundering, trade, ease of doing business, planning and facilitation, etc. So this is where the concept of co-regulation comes in. It's at Clause 30, and it also, of course, repeats itself in Clause 54. The second aspect, or rather third aspect of Senator Hussein's submission comes back to an issue we just described, 10 years experience in real estate business. Now, we wrestled with this just as we did with the brokers, because we have not yet settled the ground as to what the qualifications are in the prescribed qualifications. If I could just repeat this. What we are doing is allowing the industry to describe and settle upon what its qualifications are. And when you go to the qualifications for brokers or the qualification for real estate agents, it involves, in the brokers, for instance, accreditation. That accreditation has not yet been settled. When I went to the accreditation aspects a short while ago when most members were out of the chamber, I pointed out, when you look to licensing of brokers, for instance, Clause 40, 5, Roman 4 and Roman 5, Accreditation Council as the committee may approve. We've not settled what their qualifications are going to be yet, because in the core regulatory approach, the industry needs to settle what its qualifications are going to be, which is why we wrestled just now with the submission as to whether we should have 5 years or 7 years or 10 years. Because if we go too far and say 10 years now, what happens if very few people qualify? It doesn't give a fair opportunity for people to qualify. Now, obviously, when you say a 5-year standard, that's de minimis. If a man rolls up with 20 years experience or 10 years experience, or a woman, then obviously in the nomination prospect, the better candidate succeeds. So it's not that we're being obstinate about the limit. It's because there is a moving target right now of accreditation. For instance, my recommendation on accreditation is that this should also take account of accreditation by number of years of experience in the industry. And I gave the example a short while ago of Anthony N. Sabga, who has primary school education and has no business qualification, but was one of the greatest businessmen this country has ever seen.
Attorney General.
Yes, thank you.
Senator Richards has something to say, followed by Senator Mark. Is there anyone else who wishes to speak? Senator Hussain, this will be your last time because you made the presentation. Senator Hussain, Senator Mark, Senator Richards, Mark, Hussain, AG.
Thank you, Madam Chair. In 30, and I know the AG's amendments are in the chapeau and paragraph E, and Senator Marks in subsection 2E. But I have a concern about 32D. And is it implied by a person with experience in accounting is that that's a particular qualification level, and also how many years experience, although it is being nominated by the minister? I find it quite open.
Senator Mark.
Yeah. Madam Chair, this is a committee that is dealing with licensing, right? And there ought to be some independence. And if the Attorney General's argument is that you don't want to bring in brokers because it would be an incestuous kind of arrangement and there wouldn't be co-regulation, what this is telling us is that there are going to be 4 persons in a 7-man committee, and 4 of them will be coming from the ruling party, whichever ruling party is in power. The Tobago, you have a ruling party in power, and in Trinidad, you have a ruling party. So at the end of the day, this is going to be politically controlled, Madam Chair, by the ruling party, whichever party is in power. And what I'm saying, Madam Chair, this does not give us comfort as it relates to the independence of this licensing authority or licensing committee. And I'm asking the Attorney General to pay attention to the lopsided nature of this committee. It is unfair.
Senator Hussain.
Thank you very much, Madam President. Madam President, I would like the Attorney General to consider that I understand the point where the AG is making in terms of having some level of government representation in the licensing committee. AG, isn't it not comforting that the minister can appoint someone in terms of the accounting, business, or finance background, and also there will be a representative of the THA. So the executive does have 2 persons of their choice in the committee, and now we're going to increase the persons in the real estate business from 2 to 4. Why not at least give 2 of those persons, the association, some leverage in terms of appointing at least 2 of the persons in the real estate business?
So, Senator Richard, please, one final point.
Thank you. Just clarification from the Honourable Attorney General through you, Madam Chair. And is the President, as cited in 2, that Her Excellency the President or His Excellency the President, should that be the case in the future? Or is it to be construed as a cabinet as we've sometimes seen in the past in terms of interpretation?
Attorney General.
I sincerely apologize. I was momentarily distracted. Would you mind repeating that with
So,
the
no,
chair's leave?
Senator Richard is asking whether at 33, if that president is 32, if that president is cabinet or the president. Yeah.
In own discretion.
Yeah.
Okay, understood. Yeah? May
Attorney
I?
General, yes.
Yes, thank you. May I thank honorable senators for their submissions. I think that we're all on the same page. So even though we're not on my amendments, they factor into our discussion, and it resonates with some submissions that Senator Hussain just made, right? So we listened during the debate that we needed more industry involvement, which is why I'm going to propose, when Madam Chair allows me to, amendments to increase the number of persons from the industry to 4. If we look to, I should perhaps go in the order that sometimes it's hard to answer all the submissions when they are taken in a group, but permit me for a moment. Senator Richards asked how many years experience was required for accounting, etc. And that was with respect to subparagraph D, a person with experience in accounting, business, or finance nominated by. We've taken that formula without reference to years experience, because sometimes if you specify you want an accountant, a lawyer, or something, you end up with the board the entity not being properly comprised. In other words, then it falls out of constitution because one person is lost. So what we did there was to use the pooling, accounting, finance, business.
Is there a particular qualification level?
Yeah, so we specifically didn't put a qualification level because, again, in this industry, we were looking at the fact that they're just savvies. I'll call it the Anthony N. Sabga version. No qualifications, but beyond doubt, well qualified. So we had not put a qualification level for that point. Secondly, Senator Mark raised concerns about the independence and political control and ruling party, etc., and referenced the THA. That, from a principle point of view, I understand where the honourable senator is coming from. Obviously, and Senator Dillon Remy would know this, the reason why we have the THA in is that under the 5th schedule to the THA Act, they are responsible for land in Tobago. So we had to include the THA separate from Trinidad. The point taken, however, on independence, I'd just like to underwrite the fact that's why we have the JLSC included. And to answer Senator Richards specifically, president does mean cabinet. And the only time that president means president in discretion, in own discretion, is where you specifically say the president in his own discretion shall. So, Senator, did I get it wrong, Senator Richards, as to what you asked?
No,
You said the cabinet.
Yes, president only means president in own discretion when the law specifically says president in own discretion. The other formula is president after consultation with prime minister and leader of opposition, or president. In the latter case, in the last case, president means cabinet, and that's the manner in which it is interpreted. However, Senator Hussain made a very commendable suggestion, which I'd like to grab on to. Madam Chair, it would not be odious to include 2 persons on the recommendation of the association. And I think that there is merit in Senator Hussain's submission, and therefore I'd want, when we get to the amendments that I've proposed, to include in the 4 persons that I'm proposing, 2 persons who will be nominated by the association, so that we can have some balance. It'll take care of Senator Mark's observation as to preponderance of personalities. Whilst I hear this argument coming from the opposition, as a government member and as a person who served in opposition, I never had a problem with a cabinet appointing anybody, because a cabinet was appointed to run the country, which is why I've never made that observation when I was in opposition of pouring scorn on a cabinet making appointments. That's part of the executive's function.
So I think we're at a position now where I can put the amendment as proposed by Senator Mark, and then we'll treat with the amendment circulated by the Attorney General.
Well, in light of what the Attorney General has indicated, that he's going to make an amendment when it comes to his...
You're going to withdraw yours?
I will withdraw mine.
Thank you very much. So your amendment is withdrawn. Honourable Senator Vera.
Thank you. Thank you, Chair. Honourable Attorney
Senator
General.
Vera, can it be brief, please? Can it be brief, because I'm about to put the Attorney General's amendment. Yes, go ahead.
Well, it was simply to indicate to the Attorney General, but I think that there is an appetite that 32 should be the President acting in her sole discretion, as opposed to the President acting on the advice of Cabinet.
And Madam Chair, if I could just address that quickly. Because it's co-regulatory, the President acting in sole discretion can be very cumbersome from an executive's functionality, planning, environmental management, other aspects. There has to be a coordination of government interest in co-regulation. And remember, that interest is why a government is elected. A government has to have the capacity to run the program of development and supervision that it wants. Otherwise, it may be frustrated in that regard. I respectfully believe that the balance is there. The Judicial and Legal Services Commission is entirely independent. If we add 2 people from the association, that gives the association's point. So therefore, you're really looking at THA, which under law is the THA, and they handle Tobago matters, and now 2 people by the cabinet.
Senator Hussain, you wanted to say something? Just very briefly.
Yes, just to respond to Senator Vera also, if you look at the way in which it's drafted, the President is just making a formal appointment. It's not that the President is exercising a discretion. So I think that is important for the record. It's just a formal appointment is being made.
I just want to remind members, I don't think anyone can say that I do not allow for free discussions when we are at committee stage. But for those of you who are interested, there are 83 clauses in this bill. We are at clause 30. I just put that for my record. Senator Vera.
Thank you, Chair, and I very much appreciate just to, I understand what the AG is saying, and I would just also like to point out that 32(2) makes clear that in the performance of its functions, the committee shall not be subject to the control or direction of any person. And I think that's an important safeguard, because whoever appoints you, your loyalty is not to that person, your loyalty is to the organization you serve.
So, Attorney General, you have some surgery to do to your amendment.
I just wrote out the same thing. Yes, please. Yes, please, Madam Chair. Oh, perhaps I better read yours. I was just putting it into the speak of Clause 30.
Sure.
Madam President, Madam Chair, if you look at Clause 30 as circulated by me,
Yes.
if I could adopt the following surgery to it.
Sure.
So in subsection 2, A stays fine up until the semicolon. So I'm asking you to delete the word and.
Right.
B would be, no, you left out the removal of, and. Because in B we're looking at E, right? So you see this and, we have to remove and then drop it down into the new E and then insert an F. So that was what I was just doing. You follow? Yeah? Sweet. We're deleting the word and at the end of paragraph E, subparagraph E. In B, we're saying in paragraph E, delete the word and. Yes, so instead of to, delete the word and. And then delete the words and substitute the word. Right down to 4.
Okay.
Okay?
So delete the word to.
Yeah, and replace it with and.
Replace it with and delete and substitute the word for.
Yes, please.
All those words,
yes,
right?
please.
Yes.
Then we're going to say C. We're going to say insert paragraph F. Insert a new paragraph F, right? And it will read as follows. 2 persons, each having at least 5 years experience in real estate, business, nominated by the association. Full stop. Sorry, semicolon. And we would then say in a new paragraph after that, renumber F in brackets as G, full stop. Yeah? Yes, so just to be clear, Madam President, the circulated amendments will look like this. A, in the chapeau, delete the word 7 and substitute the word 9. B, we're going to say in paragraph E, delete the word and, in quotations, full stop. I mean,
delete the word to.
Yes.
And substitute
delete the
with
word to and substitute with the word and.
Yes.
And then delete those other words and substitute the word for.
Yes.
And then we're going to have C,
Yeah.
insert new paragraph F.
Yeah.
And the wording for paragraph F will be 2 persons, each having at least 5 years experience in real estate business, nominated by the association. And then D, paragraph D will be renumber F as G, right?
Yeah.
Yeah. hold on, I just want to make sure, I want to make sure that we've caught 4 now, right? So we're 2 short of 4. So, because we're inserting a new, yeah. So we got A, delete the word 7 in the chapeau, that's fine. In paragraph E, we're going to say delete the word and, right? Then therefore that reads 2 persons each having at least 5 years experience nominated by the minister. And then the and moves. And then we have a new paragraph F, which says 2 persons each having 5 years experience in real estate business nominated by the association. That takes us to 4. And then F returns as G. So we're fine.
Okay. Well, let's hope I am, as I put it now. Honorable Senators, the question is that clause 30 be amended as circulated by the Attorney General and further amended as follows. At A, in subsection 2A, delete the word and. In B, delete the word to and substitute with the word and delete the following words and substitute the word for. C, insert a new paragraph F to read as follows: 2 persons each having at least 5 years experience in real estate business nominated by the association. D, and D, renumber F as G.
Yes, ma'am. We insert the word and after that.
Yes.
Yes, we did.
It came between C and D. And,
Great.
yeah?
Much obliged.
Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 30 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 30 as amended now stands part of the bill.
Clauses 31 to 40.
The question is that clauses 31 to 40 stand part of the bill. The question is that clauses 31 to 40 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 31 to 40 now stand part of the bill.
Clause 41.
The question is that clause 41 stand part of the bill. Senator Mark, you have circulated an amendment. Yes?
Madam Chair, I did circulate an amendment, but it was not typed in the version that you have there.
So we have it. Clause 41. It's behind.
No. 40. And you had gone past 40. You went very fast.
There's nothing very fast about how this process is going. Absolutely nothing.
No, but what I'm saying
But
is
I'll
that
say no. So, well, if it's a new clause, it comes after. This after, but I would appreciate getting it, the copy of that amendment.
of how we are going.
Senator Mark, you have an amendment. So let's deal with the present. You have an amendment circulated for clause 41. Can you, Senator Hussain?
Thank you very much, Madam President. This amendment has to do with clause 41 sub 4, Madam President. Just in terms of the time limit in which the person has to respond where an objection is filed to his application. And we're just asking, Madam President, that the time starts to run for a person to respond to the objection from the date of service of the notice, rather than just leave it vague as the date of notice.
Else on clause 41, the proposed amendment. Attorney General.
So, Madam Chair, the first response to this is the formula that we've used from the Companies Act, the Non-Profit Organizations Act, and many other pieces of law. The issue of rule of service, date of notice, whether you're using the constructive notice or actual notice rules at law, or postal service methodologies, etc., that always becomes something that is an issue. It's always open for one to say that, look, I don't have adequate notice and therefore inform of that position. So We didn't say service of notice because I don't know if there is actually a method of service that we can certify at any one point in time without then going down to the prescriptive barrel of that. Postal notice, 24 hours after email notice. The way we would normally do it in contract is by far more particularized than it is in legislation. So we took the precedent of legislation that we have. It's worked itself out. If you look at the Companies Act, etc., when notices come about, because the legislative structure is a little bit different from the particulars that we give in a contract structure. So I understand your concern. It's a genuine concern, but we've gone with the formula that we're accustomed to in law.
Senators, the question is that Clause 41 be amended as circulated by Senator Mark. Those in favour say aye. Those against say no. Honourable Senators, the question is that Clause 41 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 41 now stands part of the bill.
Clauses 42 to 53.
The question is that clauses 42 to 53 stand part of the bill. The question is that clauses 42 to 53 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 42 to 53 now stand part of the bill.
Clause 54.
The question is that clause 54 stand part of the bill. There is an amendment circulated by Senator Mark. There is an amendment circulated by the Attorney General. Senator Mark. Senator Hussain.
Thank you very much, Madam President. Madam President, this is almost identical to the amendment that we did to the licensing committee in terms of having a more representative composition of the disciplinary committee where the association can nominate 2 other persons. And I don't know if the Attorney General will also agree with the same formula that we used previously.
Yes, Madam Chair. The same formula for the same reasons advanced and accepted and agreed.
So that Senator Hussain, you withdraw yours. Senator Mark, you will withdraw yours, yes? Attorney General, you have some surgery to do to yours?
Yes, Madam Chair, should it please you. So, here we go. So, in 54 is circulated in the chapeau, A stays the same. In B, we're going to say in paragraph C, take off the word to and substitute it with the word. Yeah, we're taking off the and, right? So, Madam Chair, if you just strike the word to as in the circulated draft in paragraph B and put the word and instead, and delete the words and substitute the words for. So that's paragraph B. Paragraph B would now read, in paragraph C, delete the word and in inverted commas. Full stop. Sorry, semicolon. Delete those words appearing and substitute the words for. Just delete those words if it pleases you. We would now say in paragraph C, a new C in the circulated amendments, we're going to say insert new paragraph D. And the wording for paragraph D would be as follows: 2 persons with at least 5 years experience in real estate business, nominated by it's not the minister. You want to go the association. It says after consultation with the association, right? So nominated by the association. Should it please you?
Yes.
Did I insert the word and? Just to be sure.
So you want to just go it over, Attorney General?
Yes, please. So, Madam Chair, that which is circulated as amendments should read as follows. In subsection 1A, that stays the same. In the chapeau, delete the word 7 and substitute the word 9.
Yes.
Scratch the word and. Paragraph B would read, in paragraph C, delete the word and in inverted commas, semicolon. We should put in the word and after that. And then now a new paragraph C, which reads, insert new paragraph D, and that reads, 2 persons with at least 5 years experience in real estate business nominated by the association.
Okay. So, all right.
And Madam Chair, we have one more thing to do because I'm just looking at the bill itself, right? And we'd have to say in E, forgive me, right? We'd have to say D, we're going to have to say renumber paragraph D as E as in echo. So the and really comes after paragraph C, okay? Semicolon after association and. Thank you.
Okay, so I think I have it now. Honorable Senators, Senator Vera.
I had just a question. I noticed there's no indemnification of committee members, and I'm wondering whether that was an oversight.
You meaning an indemnification for them acting for bona fide purposes, etc.?
That you will not, because very often when people go for judicial review or they sue, they bring the actions against them personally, and they are not necessarily, so whether that is something you would want to consider.
So I wouldn't want to introduce that concept just yet because there are a whole other bunch of laws, if I could be as positioned as that to say, that I'd have to treat with. All of the other committees that we've established in recent bills, we've not included an indemnification provision for them. So you're asking whether an indemnification clause for the committee should be included. I would assume also, therefore, for the licensing committee, right, to say that they would not be subjected to personal liability.
Bias or misconduct.
Correct. Okay.
Senator Vera, may I respectfully ask for room to think about that? We have a miscellaneous provisions coming up next, but this is a matter of policy that I'd have to get right in the exculpation of liability and indemnity, because I can do it in one of 2 ways that I've not settled on yet. That no action shall be taken for them acting in good faith or not in bad faith is one version of indemnification, as opposed to indemnification in their own personal right. So may I do that? Because you can also meet an indemnification by the committee agreeing to indemnify its members by resolution. So it can be done administratively as well. So I need to be certain on which one of those 3 versions one should accept in legislation.
I'm fine with that. It's just when people are called upon to serve in these capacities, they want to be assured that they will not have personal liability unless they look for it.
Much obliged.
Honorable Senators, the question is that clause 54 be amended as circulated by the Attorney General and further amended as follows. In A, delete the word and. At B, delete the word to and substitute the word and then delete and substitute the word for. C, insert new paragraph D to read as follows. 2 persons with at least 5 years experience in real estate business nominated by the association, semicolon, and D, renumber paragraph D as E.
Perfect.
Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The question is that clause 54 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 54 as amended now stands part of the bill.
Clauses 55 and 56.
The question is that clauses 55 and 56 stand part of the bill. The question is that clauses 55 and 56 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 55 and 56 now stand part of the bill.
Clause 57.
The question is that clause 57 stand part of the bill. Senator Mark.
Madam Chair, I really would like to, I was trying to get clarification on the matter, Madam Chair, but I think you have,
Senator Mark, can you please speak up? I can't hear you.
I'm seeking your indulgence.
Yes?
To reopen 56. I just need to get out a clarification from the Honorable Attorney General.
Well, you can ask for the clarification. I'm not going to re-put it to the committee.
Okay.
Just very briefly ask the Attorney General for clarification.
But Attorney General, who is going to, again, where are these people going to be finding money from to pay this for the staffing of the disciplinary committee as the association?
From the association's dues, which will underwrite its purpose, just like the Law Association, engineers, dentists, everybody, except the Land Surveyors Association.
Yeah, but they are not in charge. They are not in charge of this committee. I mean, they say we are piling up all kind of people, except for two that you just agreed to.
They are receiving the benefit of the committee, so they don't need to be in charge.
So why must I be receiving the benefit of the committee and I'm paying for it? I must be in charge.
No. The public...
Anyway, I'm trying to withdraw. I'm not going further with that.
Thank you very much. So we now deal with your amendment to clause 57, Senator Mark. Would you like Senator Hussain? Senator Hussain.
Thank you very much, Madam Chair. This amendment is an amendment to clause 57 sub 2. We saw a disparity, Madam Chair, through you to the Attorney General, that the members of the disciplinary committee will be paid, the members of the licensing committee will be paid, but not the members of the association. So we were wondering whether or not, just for equality of treatment, whether or not the members of the association could be remunerated for their services, because they will be doing quite a lot of work in terms of the management of this particular piece of law.
Sure. So they're not in similar circumstances. The disciplinary committee and the licensing committee involve external entities, the JLSC appointees. So they're coming to do quasi-judicial functions which have significant work and liability inside of the arrangements. For those reasons, it was appropriate to remunerate them because they're outsiders in part as well. The association itself is meant to be a volunteer association for the work that they do. There is no honorarium that's paid to the Law Association as far as I'm aware, the Dental Council, the Medical Association, etc. So none of the self-regulatory bodies exact remuneration for themselves. In fact, I believe it is in associations of another type, I wouldn't call them here today, that kind of difficulty comes about because of the remuneration factors. So we wanted to stay clear of that. Just like the Law Association, you volunteer to be a member of the Law Association and you do it for free because you're really giving service to the association.
So, Honourable Senators, the question is that clause 57 be amended as circulated. Those in favour say aye. Those against say no.
No.
I think the noes have it. The question is that clause 57 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 57 now stands part of the bill. 57, 58 to 62. We'll do it in parts. Yeah?
In parts from this point.
58 to
Clauses 58 to 62.
The question is that clauses 58 to 62 stand part of the bill. Senator Mark.
May I, through you, advise the Attorney General, seeing that we have increased the disciplinary committee by 2, from 7 to 9, I would respectfully suggest that the quorum be increased from 3 to 5, so you have a proper balance.
May I ask what clause you're dealing with?
I am dealing with clause 16, Madam President. Madam
Attorney
Chair.
General.
I had not spotted that. So I think that that's very prudent, Madam Chair. May I?
Just a second. So the question is that clauses 58 and 59 stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Clauses 58 to 59 now stand part of the bill.
Clause 60.
The question is, that clause 60 stand part of the bill. Attorney General, you have a form of words?
Yes, Madam Chair. I wish to thank Senator Mark for observing need for an amendment at section 60, clause 60. I see a look of consternation above Senator Vera's mask, however.
No, hold on. Attorney General, are you proposing an amendment before we deal with Senator Vera?
I don't want to be guilty of a knee-jerk amendment if there's a voice on the table.
Senator Vera.
Thank you, Chair. If we are talking about a quorum of a meeting where it's an administrative type thing, 5 is fine. But if the amendment is 5, it means that every disciplinary hearing must have at least 5 members. That could sometimes be difficult, getting a quorum. 3 is usually a norm, at least in disciplinary committees that I'm involved with, where they would have panels of 3. So I'm just saying 5 is a high number.
Hence the benefit of discussion, Madam Chair. Thank you for facilitating it. Senator Vera just reminded me of panels. And if we're going to have a workflow, rate flow, like the Law Association, we have a panel A, a panel B, etc. You may very well be finding the committee sitting in smaller numbers, and therefore we may unwittingly throw the baby out with the bathwater. I do understand what Senator Mark was saying, though.
Governing this piece of legislation, we can make provision for panels, right? And we can house there that proposal. But for the legislation, we are saying that if the disciplinary committee is to meet, not necessarily to hear a matter, but they may meet as a body. I am saying that if you have a membership of 9, we should go with 5. But I agree with you and Senator Vieira. In our regulations, when you set up your panels, you can say a panel will be made up of 3 members for hearing purposes. That is what I would agree to.
So, Madam Chair, I thank Senator Mark for that observation, but unfortunately, the reverse is really the case. Once the law says that the disciplinary committee is at 5, we can't derogate from the law by saying the committee may sit at 3. So what we can do instead is in the regulation say you can move up because there's nothing to stop you from going in the panel arrangements to say 4, or usually go for odd numbers, right? But I think that because of the observation that Senator Vera raised just now, the mask allows the consternation to be a little bit more defined. But I thank Senator Vera for expressing that. So may I retreat from a recommendation to amend Section 60? Most respectfully.
So the question is that clause 60 now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Clause 60 now stands part of the bill.
Clauses 61 and 62.
The question is that clauses 61 and 62 stand part of the bill. The question is that clauses 61 and 62 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 61 and 62 now stand part of the bill.
Part 10, clauses 63 to 71.
The question is that clauses 63 to 71 stand part of the bill. The question is that clauses 63 to 71 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 63 to 71 now stand part of the bill.
Part 11, clauses 72 to 77.
The question is that clauses 72 to 77 stand part of the bill. The question is that clauses 72 to 77 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 72 to 77 now stand part of the bill.
Part 12, clauses 78 to 83.
The question is that clauses 78 to 83 stand part of the bill. Senator Mark?
I ask the Attorney General, because of the...
Which clause, Senator Mark, please?
I'm dealing with clause 80.
80. So then let's say the question is that clauses 78 to 80, 78 and 79.
No. Let me see, just a madam. Yeah, you're correct. Sorry.
The question is that clauses 78 and 79 stand part of the bill. The question is that clauses 78 and 79 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 78 and 79 now stand part of the bill.
Clause 80.
The question is that clause 80 stand part of the bill.
Madam Chair, yes.
Yes.
Through the Chair to the Honorable Attorney General. Madam Chair, we are talking about the formulation of a code of ethics, and we are also talking about a lot of matters that will have to be addressed through regulations. And because of the nature of this bill and its provisions or clauses, I would like to ask the Attorney General to consider bringing these regulations for debate in this Parliament, particularly when it comes to the Code of Ethics, Madam. I'd like him to consider
To change negative to
yes,
affirmative. Attorney General.
So, Madam Chair, I thought Senator Mark would notice that this is one of these occasions where we subjected the order to negative resolution, because we believe that the Parliament should be made intimately aware of this, because it's a co-regulatory approach. So for that reason, we didn't do the normal thing, which is to say just an order and not have the inspection of Parliament. But because of the difficulty in the manner in which affirmative resolution works, it's an extremely cumbersome thing when you're trying to amend that which you've brought. It's by far better instead to bring a negative resolution and then cause surgery to it. So we respectfully believe that the step up from order into negative resolution is the way to treat with this issue.
So, Honourable Senators, the question is that clause 80 now stand part of the bill. Those in favour say aye.
Aye.
Those against say no. I think the ayes have it. Clause 80 now stands part of the bill.
Clauses 81 to 83.
The question is that clauses 81 to 83 stand part of the bill. The question is that clauses 81 to 83 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 81 to 83 now stand part of the bill.
Are you going there after?
I am.
I have been advised that my proposal via an amendment is not a new clause. It's really an amendment that will create a new, create a subclause under Section 40. So there's where I will need your guidance. Remember, you had indicated, based on my submission, that being a new clause, you'll take it at the end. But I've not been advised. It's not a new clause. It's just a subclause.
Senator Mark, do you have the amendment in writing?
No, I have it right here.
No, Senator Mark.
No, what I'm saying, ma'am,
I
is
know,
that...
but Senator Mark, we are...
I know.
Literally, we started the committee stage at... I have it written down.
Yes, ma'am.
We have spent at this stage without a written amendment on your part. I don't see how I can revisit the clause.
Yeah, but all I'm saying is that I submitted a written position, but it was just left out, inadvertently. It's not to say I didn't do it. I did it. No, I'm a Democrat. You're mad or something? I'm famous for being
Senator
a Democrat.
Mark,
Madam Chair.
I am going to deal with the schedules, and if I am finished with the schedules and you do not have a written amendment to submit to me, then I'm afraid we are finished.
Can I have a piece? Can I have that book so I can write quickly? So can I have that quickly?
I will give it to you, Senator Mark. Here you go. Right? So, we will now treat with the preambles, the schedules, sorry.
Schedule 1.
The question is that Schedule 1 stand part of the bill. The question is that Schedule 1 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Schedule 1 now stands part of the bill.
Schedule 2.
The question is that Schedule 2 stand part of the bill. Senator Vera.
Through you, Chair. Should the Data Protection Act also be included?
May I?
Yes, Attorney General.
Would love to, but it has a lot of unconstitutionality in it that needs surgery. That's why the Data Protection Act has not been proclaimed. If you recall, the Media Association had violent objections to the Data Protection Act, which I share. And secondly, the Data Protection Act is going to have to be massaged a little bit further as we're doing the electronic transactions reformation of Trinidad and Tobago. This government is going completely E-oriented. So we've established the MOU with the government of Estonia at the AG's office and Ministry of Works and Transport. We're light years ahead, intellectual property. So that's why we've not had amendments to the Data Protection Act yet, because it's now archaic in light of electronic management. So I do agree, the current act has some terrible unconstitutional issues inside of it. That's why the last government only partially proclaimed it, and we certainly have not. And I intend to cause the surgery to that. After we get over the election and are back into gear in government, we will amend those provisions with the electronic arrangements.
So the question is that Schedule 2 now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Schedule 2 now stands part of the bill.
Schedule 3.
The question is that Schedule 3 stand part of the bill. The question is that Schedule 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Schedule 3 now stands part of the bill. I'm just all developers, where is this? Two?
Clause 40 revisited.
So because the milk of human kindness is flowing right now, I will just read to members what Senator Mark is proposing, Attorney General. Senator Mark is going to be a very brief presentation on this. Clause 40. Senator Mark is proposing add new subclause 242 to read as follows. All developers are required to be licensed under this act. Yeah?
Yeah, Madam Chair. The Honorable Attorney General indicated that...
Senator Thompson, aye. So, Senator Mark, Senator Mark is asking that a new 42 be inserted to read as follows, and then everything will be renumbered accordingly.
So while we're on 41...
No, we're not.
Okay.
We're on 42. We are on Senator Mark's proposed amendment.
Can I just say one thing, though, about 41? That I would like, yes, please, that the American spelling be changed to the English spelling of license?
That is for the Attorney General to know.
Yes, please.
Yeah.
Yes?
You have a license with a C,
So,
but it's
so
licensed.
Madam Chair, the CPC's department is saying that they will pick that up in the proofreading and they will change it to the correct spelling. Thank you so much.
Sure. So, Attorney General, 42, all developers are required
I'm sorry,
to be
Madam
licensed.
Chair. 402, 42, or I'm not following.
40, subclause 2,
Yes.
to read as follows: all developers are required to be licensed under the Act, under this Act.
And then is there the proposal that everything else is renumbered accordingly?
Well,
That
yeah.
would be it, Madam
Yeah.
President. I
Yeah.
think but that would follow logically.
Senator Mark, can you
Yeah,
therefore...
Madam Chair, I am submitting to the Honorable Attorney General that since brokers as well as sales associates, or what they call real estate agents, are to be licensed in this legislation because they engage in that kind of exercise. Here we have developers developing land, building houses, and selling houses, and they are not being asked to be licensed. I believe that it is unfair, and we need to bring some regulation to developers. And that is why I propose that they be also licensed as any other category, broker, as well as sales agent / real estate agent. So it's as simple and as straightforward as that, Madam Chair.
Sure. I thank the Honourable Senator for his recommendation, and I understand the heart of what he's trying to drive at. Unfortunately, it's not simple. To license developers under the Real Estate Agents Act is to clothe them in the business of real estate. The business of real estate is set out in the bill under 4, Clause 4 and Clause 5. Clause 4 is a disapplication clause. Clause 5 is where we set up what a real estate agent does, and in the second part of Clause 5, we say what is not included in that. People acting under powers of attorney, as receivers, as liquidators, etc. Because developers, if they are to be licensed, would have to have terms and conditions of license, standards of license, regulatory supervision of licenses, disciplinary committees for that type and subset of position, a licensing committee that treats with that. We're actually looking at a very involved subset for developers. Furthermore, to interfere with the right to hold property under the Constitution under Section 4, constitutionally we'll have a huge problem to tell people who own property, before you can develop, before you can treat with your property, you need to be licensed. That would be a massive 3/5 right issue that we just can't include into this legislation. So, A, because of constitutional reasons and the intrusion into Section 4 rights, B, because of the need for terms and conditions with respect to licensing as it relates to what you're going to license, what are the parameters of the license, C, because of the need to institute a committee that has the skill set to do that, and D, because of the need for consultation on such a mammoth recommendation. That's why we, Senator Rambarat, dealt with it, said that we would take that in a separate law, because we don't only want to have licensing of developers, we must factor the planning and facilitation development across complex development and simple development in the devolved aspect. It ties into the property tax regime and land tribunals. It ties into the Registration of Title to Land Act. It also ties into the concept of advertising for development. So that's a very complicated issue to describe on the floor on the recommendation of the Honourable Senator.
Madam Chair, I wouldn't be too long. All I would say is simply this. I've looked at 3 different pieces of legislation, and the definition for developer is very clear and simple. It focuses on land and the selling of individual lots. Had nothing to do with the building of houses and the sale of those houses. Here it is, and so on, Madam Chair. We are moving away from that concept, and we have expanded it. No property rights were violated. No 3/5 was being called upon. But here it is, Madam Chair. We have a serious matter where we have redefined developer, but we are saying we cannot go further in terms of licensing. I disagree.
So,
Madam
Honourable
Chair.
Senators, I shall now propose the amendment. The question is that clause 40 be amended as proposed by Senator Mark as follows. Add new subclause 42 to read as follows. All developers are required to be licensed under this Act, and renumber all other subclauses accordingly. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question, therefore, is that clause 40 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. The ayes have it. Clause 40 now stands part of the bill. Honourable Senators, the question is that the bill as amended be now reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate. Attorney General.
Madam President, I wish to report that a bill entitled the Real Estate Agents Bill 2020 was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on a bill entitled the Real Estate Agents Bill 2020. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Madam President, I beg to move that a bill entitled An Act to Provide for the Registration and Regulation of Real Estate Agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estate agents, and to assist in the detection and prevention of money laundering and terrorist financing and other related matters be read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Provide for the Registration and Regulation of Real Estate Agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estate agents, and to assist in the detection and prevention of money laundering and terrorist financing and other related matters be now read a third time and passed. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Provide for the Registration and Regulation of Real Estate Agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estate agents, and to assist in the detection and prevention of money laundering and terrorist financing and other related matters.
Leader of Government Business.
Madam President, I beg to move that the Senate do now adjourn to Tuesday, the 26th of May, 2020 at 1:30 p.m. That will be Private Members' Day, and I'm informed by the Leader of the Opposition Bench that we will be continuing debate on motion number 1 on Private Members' Business. That's the motion on crime. where the Senate adjourned that debate on Tuesday, February 4th, 2020.
Honourable Senators, before I put the question, I now invite Senators to bring greetings on the occasion of Eid, which is going to be commemorated on Sunday, May the 24th, 2020. Leader of Government Business.
Thank you very much, Madam President. Madam President, on this side, we are privileged to have a Haji in our midst in the person of Senator the Honorable Haji Kazim Hussein. He would normally have been giving this address, but he had to go to San Fernando to break his fast. So as the only remaining can in the house, I could not obviously assign this task to anyone else. So, Madam President, I thank you for granting us the opportunity to bring Eid ul-Fitr greetings in this honorable house to the Islamic community of our beloved nation. Eid ul-Fitr marks the joyous end to the holy month of Ramadan, a month in which we deepen our understanding of Islam with spiritual reflection and renewal, increased devotion and worship, recommitment to the values of gratitude, charity, and compassion. This year, unlike previous years, Madam President, was a family Ramadan with a difference. Due to public health and precautionary measures implemented across the world to treat the current COVID-19 pandemic, Muslims near and far had to alter the way that they would traditionally perform certain rituals during the holy month. Though they were unable to congregate at their respective masjid for Taraweeh prayers and share in the daily breaking of fast, iftar, with our brothers and sisters in Islam, they remain firm believers that Allah is all-knowing, as the Quran in chapter 94:6 reminds us, verily, with every hardship comes ease. Madam President, we truly believe that this sacred month of Ramadan was a test for each and every Muslim, a test by Almighty Allah to draw closer not only to Him, but to our loved ones, in deeper reflection of the Holy Quran. During this month, while being physically separated from their religious communities, Muslims were presented with a greater opportunity, one where they could focus on repairing and building even stronger bonds with their families, mothers, fathers, brothers, sisters, husbands, wives, and children. With most family members at home, Muslims were able to share this period of deeper prayer and fasting together, and it further encouraged children to join in the daily rituals which are prescribed in the Holy Quran. Madam President, as a nation, we have witnessed the devastating impact of this virus continues to have across the world, leaving families without basic necessities to survive, and even leading loss of many lives. But through it all, Trinidadians and Tobagonians have learned valuable lessons in gratitude, camaraderie, charity, and having faith in the Almighty at all times. Madam President, Eid ul-Fitr serves a threefold purpose. One, it places all Muslims the responsibility to remember Almighty Allah and offer Him thanks. Two, it affords us the opportunity for spiritual reflection, to understand the strengths of our will and to recognize the weaknesses of our character, which would have revealed themselves during the holy month. And three, it is also a special day for us to share with our less fortunate brothers and sisters. In preparation for Eid ul-Fitr, I encourage our brothers and sisters in Islam to reflect upon the lessons learned during this month-long fast, show gratitude and compassion to the needy and to those less fortunate in our society, and let us continue to strive to implement the lessons learned from Ramadan in our everyday lives. In conclusion, Mr. Vice President, on behalf of the government of Trinidad and Tobago, I take this opportunity to wish our Muslim brothers and sisters at home and abroad, and the entire national community, Eid Mubarak. Here in this House, I extend my personal best wishes on this joyous occasion to my colleagues on the government bench, to my colleagues on the opposition bench, and to my colleagues on the independent bench. Eid Mubarak to you and your family. But in closing, what is uniquely Trinidadian in a scenario like this is our unique ability to celebrate together and respect each other. At Easter, the entire country celebrates, showing great respect for Christianity. At Diwali, the entire country celebrates, showing great respect for Hinduism. And today, and in the coming days, we celebrate Eid al-Fitr as a nation, with the entire nation showing great respect and love for our Muslim brothers and sisters. May the guidance and blessings of Almighty Allah be with you and your family now and always.
Senator Hussain. Thank you very much, Mr. Vice President. Bismillahir Rahmanir Rahim. I begin in the name of Allah, the most gracious and the most merciful. Thursday, 14 June 2018 will be one of the most memorable days in my life as I rose in this honorable Senate to bring Eid greetings to Trinidad and Tobago on behalf of the opposition. At that time, I was brought to tears in the chamber as I was in disbelief that a young man like myself would have been given the opportunity to stand proudly in the Parliament of Trinidad and Tobago to bring greetings on the occasion of Eid. Today I stand here again as that same proud young man, bringing greetings to our nation on this auspicious occasion. However, with the certainty this time that it would be the last, as we as a Senate will celebrate Eid al-Fitr together, as this is the 11th Parliament, will come to its natural end in September. I would like to genuinely wish all our colleagues who have served our country and have indicated their exit from public life, success, and happiness. As we celebrate Eid in this worldwide crisis, the COVID-19 pandemic, it has taught all of us one thing, that things are not the same. During Ramadan, the doors of the mosque are normally wide open, with Muslim brothers and sisters attending more regularly, praying extra salah, especially in the night, the Tarawih salah, and breaking the fast together at the iftar. However, this year we celebrate while the doors of the masjids are closed. But while the masjids, the temples, and churches are closed, Mr. Vice President, the silver lining is that each home now becomes a masjid, each home now becomes a temple, and each home now becomes a church. Eid al-Fitr marks the end of the month of Ramadan, a month of immense sacrifice and fasting. Fasting has been made compulsory for Muslims as it is one of the 5 pillars of Islam. It is the act of refraining from food and drink from dawn till dusk and from prohibited acts. Today, more than ever, we recognize the importance of our fast. While our bodies become weak as we are met with hunger and thirst, our spirits becomes enriched. The feeling of hunger and thirst reminds us of those who are without food and drink. It makes us truly understand how one feels to be without food and drink. It reminds us that we must give back to society and assist those who are poor and needy. Ramadan is the most auspicious month in the Islamic calendar. As we are in the last 10 days of Ramadan, the odd nights in this month are very auspicious for us. While it is not confirmed which is the night of Laylatul Qadr, tonight being an odd night, the 27th night of Ramadan, many of us will observe the night of power, which is called Laylatul Qadr, where we engage in an entire night of prayer. It is mentioned in Quran that this night is better than 1,000 months. And as we near the end of Ramadan, this period of intense sacrifice and prayer. We welcome the celebration of Eid al-Fitr. Muslims throughout Trinidad and Tobago will look out for the sighting of the moon on Saturday. And if the moon is sighted, we usher in the celebration of Eid on Sunday. And as I raise my hand in prayer, I pray that our world can heal after this pandemic, that our country of Trinidad and Tobago can be truly united and heal those wounds of division, that our nation will return to prosperity, and that all of our citizens can enjoy a proper standard of living, that we can be kind to each other and be our brothers and sisters' keeper. I beg that Almighty Allah shower His choicest blessings upon our country and our citizens, and may He grant us a peaceful, happy, and joyous Eid al-Fitr. Eid Mubarak on behalf of the opposition bench to everyone in the Senate. Thank you very much.
Senator Dionne.
Thank you, Mr. Vice President. It is with pleasure that I bring Eid al-Fitr greetings on behalf of all senators of the independent bench. In our diverse society, it is estimated that about 5% of our population are Muslims. The Muslim religion was introduced to this land through two primary streams. One, Muslims were brought from African ports to this country as enslaved people. The second stream was made up of East Indians brought here as indentured laborers. Despite being a numerically small part of our population, the Muslim community has contributed to every aspect of our national life. Ramadan is the holy month when it is said that the Quran was given to the Holy Prophet Muhammad. May peace be unto him. This month, Muslims fast, not to test their will, but to perform acts of faith which brings them closer to God. It is believed that the gates of mercy are open, so the charitable deeds which you do in this month of Ramadan multiply your blessings from God. This year, we as a country must be especially grateful to the Muslim community. They have doubled their charitable efforts to feed the hungry, house the homeless, and to do numerous acts of human kindness, especially in the rural areas of Trinidad and Tobago, as we as a population reeled from the effects, or continue to reel from the effects of COVID-19. The end of Ramadan is celebrated on Eid al-Fitr. The sacrifices of the month are supposed to prepare our Muslim citizens for a new start in life's journey, one of patience, sympathy, and humanity, cleansed from the stresses of the past. It is in this context that on behalf of the independent bench, I say Eid Mubarak to the Muslim community of Trinidad and Tobago.
Honorable members, as we draw closer to the end of Ramadan, I wish to extend my greetings for the celebration of Eid al-Fitr. Let us use this auspicious occasion, which marks the culmination of prayer and fasting, to recommit to values of compassion and gratitude, and furthermore, reflect on the tradition of helping our neighbors. Trinidad and Tobago, being a diverse nation, is a great reminder that this nation has been built by people of all backgrounds and faiths. The key contributions of our Muslim brothers and sisters have been pertinent to our growth. I send my best wishes on behalf of the Parliament of Trinidad and Tobago and the members of staff of the Parliament to all Muslims, and in fact, all of Trinidad and Tobago. Eid Mubarak.
Honourable Senators, the question is that this Senate do now adjourn to Tuesday, the 26th of May, 2020 at 1:30 p.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate now stands adjourned to Tuesday, the 26th of May, 2020 at 1:30 p.m.